This video is about the 1 to 4 family residential resale contract promulgated by the Texas Real Estate Commission. I go through the entire contract, one paragraph at a time, so this video is long. But I also link to each and every paragraph in the description below. Just click below and you can jump right to the section that interests you most and get your information that way. I also want to mention that TREC updates these contracts from time to time. I'm not able to keep up with the videos to revise and update my videos quite as often as they make changes. So what I'll do is I'll link to the most updated version of the contract in the description below, and also any rule changes and contract revisions that they're proposing. I'll link to that below as well. And the reason why I'm not able to keep up with them is because I'm actually the broker and owner of Chandler Realtors here in the Dallas-Fort Worth Metroplex. I'm using this contract every day. I've been in the business for 20 years, and I'm absolutely passionate about teaching people about this contract and helping clients buy and sell houses. I'm also passionate about training our agents so that our buyers and sellers can know for sure that they're dealing with the best expert in the industry whenever they're dealing with anybody in our real estate team. And so whether you're a buyer or seller that needs somebody to help guide them through a transaction or make sure that you're maximizing your real estate goals, or you're a real estate agent that wants to align yourself with somebody with similar values that absolutely values training, and I've got more leads and more opportunity than we can handle right now, so I need all the help I can get, feel free to reach out. And I'd love to help you. Also, if you have questions that this video doesn't answer, just leave a comment down below. I get to those comments pretty quick, and I love answering questions. I love helping how I can. And if you want to encourage me to make more of these videos, just click the like button, and it helps boost the video up in the algorithms. And I love making these videos. I just don't have time to do it as often, but the more encouragement I get, the more videos I'll make. If you want to see more videos like this, just subscribe. Let's dive right in, and let's get rocking on this contract. Here we go.
First, we're going to cover when to use this contract and when to not use this contract. Then we'll begin with some conceptual topics, and as we continue, we'll drill down into some more nuts and bolts topics. So first, the high level, we'll go over why it's important to learn these contracts. Then we'll go over the mindset that you and I must have when we're going through these, and the mindset that people have as they're interacting in a transaction. Next, we'll go into how to actually use the contract, how to make offers and counteroffers. We'll discuss why words matter, and we'll talk about some general information about the contracts. We'll go over an overview of the contracts themselves. Then we'll drill down and go through the entire 9-page contract, one paragraph at a time. As we're doing that, I'll discuss what to put in the blanks from the perspective of the buyer and the seller. And I'll also go over the pre-printed black and white text. Along the way, we'll discuss best practices. Let's get started. When to use this contract and when not to use this contract. So we'll go over the when to use it first. If you're purchasing or selling a residence of 1 to 4 units in Texas, you should use this contract. Meaning if it's a single family home, a duplex, a triplex, or a quadplex, then you should use this. This form is the form that you'll use most often when you're representing buyers or sellers in a traditional real estate transaction. I even recommend investors use these TREC contracts for many reasons that I won't really go into, but if you want to know, just give me a call. You're going to use these contracts if the property is 1 acre or under, even if it's a short sale, if it involves owner financing, if it's a contingency offer, if it's a backup offer, if you're assuming a loan, if it's in wetlands or coastal area, if it's in a homeowners association or not, whether it has the mineral rights or not, whether it has lead-based paint or not, or whether you're even using a reverse mortgage to purchase the home. In all those scenarios, you would still use this contract. The time you would not use the contract is if it is unimproved property, like raw land or vacant land, just a lot. If it's new construction, you wouldn't use this. If it is considered a farm or a ranch, meaning most of the times if it's over 1 acre, then this would not be the best contract to use. You'd actually use the farm and ranch contract. But some other properties that maybe have 2 to 5 acres, there might be some circumstances you would use the 1 to 4 family residential resale contract, but for the most part, if it's over 1 acre, you wouldn't use this. You would not use this contract if it is a condominium, if it is over 4 units, or if it's a commercial property. Now let's discuss the importance of learning these contracts. You must be intimately familiar with this contract. In many ways, this is your business. All we do is help people come to an agreement to purchase and sell real estate. This contract is the agreement. Expect for your client to read this contract. And if your client reads this contract and asks you questions and it becomes clear that you don't know what you're talking about, the client will begin to view you as an obstacle or as useless. You'll turn into an order taker or a paper pusher. This is the area you're supposed to be an expert, so be an expert. Take this training serious. Learn this contract inside and out. You must know more than your client. As a general rule of thumb, whether it's this contract or another contract, you should always, at a minimum, carefully and slowly read through each line of the contract before you get into any transaction involving any document. And so this is what you're going to get out of the training. If you learn these contracts and you become very knowledgeable and an expert in this area, then you're going to feel more confident, which is going to make you happier. Your negotiating skills are going to improve. You'll be looked at as more of an expert. And inside the transaction, you will gain authority, which will cause the other agent and the parties involved to just comply. They'll understand that you know what you're talking about. And they're just going to follow behind you. Clients will trust you more, and it'll lead to less headaches. And clients will refer you more business. The trust will leverage into more business for you, and you're going to end up making more money. So it's not a magical process. It's just what happens when you become an expert. Now, I want to discuss my mindset as I enter into a transaction and as I'm learning about these contracts and working with the contracts, and the mindset of everybody else involved. So my focus is first and foremost to serve my client's best interest, and usually I'm hoping that means that they're interested in reaching an agreement. So my focus really is serving my client's best interest and reaching an agreement. It's important to aim for a win-win agreement because the contracts aren't the end-all solution. The contracts are only as good as the people writing them. They don't work if the parties involved decide not to follow through on what's been agreed upon. If someone doesn't feel like they're in a fair agreement, they may decide not to follow through. So that's why when a conflict occurs, I focus on coming to an agreeable conclusion, and I try not to focus on who's right or wrong. When the focus becomes who's right or wrong, the objective changes from getting something accomplished and coming to an agreement, and it changes into who's going to win the debate or win the fight. And if it's escalated, fighting really costs a lot of time and money. If we end up in a courtroom, I promise you, the only people that'll be winning are the attorneys. It's important to know who's actually right or wrong so that we can have a better perspective on how to reach an agreeable conclusion. Who or what is actually wrong isn't always as relevant as what the other person thinks is right or wrong, because at times it can be counterproductive to try and convince someone else that they're actually wrong regarding a specific issue. So if we know these contracts inside and out, we can accomplish more, avoid conflicts, and because we'll have the ability to be more deliberate in our actions and communicate with greater clarity, we will actually close more deals and with greater ease. It'll just have a better result all around. Again, we learn this stuff so we can be experts, serve our clients well. Most people just want a fair shake and expect for each other to do as we've agreed. Putting all this stuff in writing provides specific and accurate communication. So everybody's on the same page and we all work towards the same conclusion. Our goal is not to take these contracts into court, but it's just so everybody can understand what we've agreed on. Let's go over how to use the contracts. The first step is usually just for the buyer to write an offer. So what is an offer? An offer is made by simply filling out the contract to fit the terms you would agree to, and then you send that contract over to the seller. So after the buyer's done that, they send it over to the seller. If the seller likes what the buyer proposed, then the seller can just initial and sign the contract, and then we'll have an agreement. Now, if the seller isn't happy with the terms proposed by the buyer, for instance, if the buyer proposed, say, a $300,000 purchase price, but the seller didn't like $300,000, the seller wants $310,000, then the seller can make a counteroffer. This is done by striking through the terms that they don't agree to and then writing in the new terms that they would like to propose. So in this case, the seller would draw one line through $300,000, and right beside it they would write $310,000, and then the seller would just initial any changes made. So then send that contract, the altered contract, back over to the buyer. So now the seller's initialed and signed everything. They've initialed the changes. And so then next, if the buyer agrees to the changes that the seller's proposing, then the buyer will just initial those changes. Then we'll have an agreement. Then we'll move on. If it doesn't happen like that, then this just continues. We just keep going back and forth until it becomes clear that the two parties won't reach an agreement or until an agreement is made. Just a note, it is acceptable to respond to an offer or counteroffer verbally to help expedite the negotiations. Just realize that the verbally negotiated terms can't be enforced until they are reduced to writing and agreed upon, signed, initialed, and the contract is executed. Before you make a verbal offer, keep in mind how that will serve your strategy. Sometimes speed is very important, so verbal offers are a good idea, but presenting a counteroffer in writing can convey a message that might be taken more seriously. So just do whatever's best for your situation and your strategy. Also, don't be surprised if you verbally agree on something and then the seller decides to take another higher offer. Keep in mind, verbal negotiations, they just can't be enforced. Next, let's talk about why words matter. So this is interesting to me. A contract, all it is just a bunch of words that put together form ideas, and those words have definitions. And so the meaning of these words matters a lot. And that's what attorneys get paid the big bucks, because they are masterful at using words and they understand the fullness and maybe even a deeper meaning of the words that we're using. So just carefully consider the definition of the words on the contract and what the words really mean. So real quick, I want to define just a few words for you before we get into this too deep. The word shall is a word that you're going to see a lot, and you can just substitute the word must for the word shall if that helps you better understand the sentence. Something else that you're going to hear me talk about and see in the contract is the word addendum and the word amendment. I want to talk about the differences between these. Both of these documents are used to change the terms of the agreement. The real difference between them is when those documents are used. An addendum is used at the same time you're coming to agreement in this main contract, this 1-to-4 family residential resale contract. Sometimes you'll have an addendum or two that will accompany it, and you'll sign those at the same exact time you're signing the main contract. An amendment would come into play later. Let's say you've agreed to everything. You've signed contracts and addendums and everything. You've got a solid agreement. Well, if the buyer and seller decide to change the terms of the contract after the fact, they would fill out an amendment. So some circumstances where you might amend the contract would be if you were changing, for instance, a deadline or trying to negotiate repairs. Also, I want to just go over what the word promulgated means. Promulgated, in short, it just means to publish or to make widely known or to put into effect and make up official proclamations. So when we say that this is the Texas Real Estate Commission promulgated contract, then it's just Texas Real Estate Commission is the one that's putting it out there, basically. Now let's start talking about the contracts themselves. I want to go over a little bit of an overview of these documents. So these documents were drafted to clarify common issues, and they're drafted to be fair, so as not to favor the buyer or the seller. It's really what you put in the blanks that gives one party an advantage over the other, potentially. The contracts are also updated once in a while, and you just want to make sure that you have the most recent copy of the contracts. The Board of Realtors can actually fine real estate agents or realtors if we're using an outdated form. So if you're a realtor and someone sends you an offer on an outdated form, all you have to do is just politely ask them to redo it on one of the most recent forms, and it's really not that big of a deal. Also, if there's a TREC promulgated form for a specific area or specific purpose, then you want to use that form. We're actually required to use TREC promulgated forms unless our client insists on us using something different. For instance, let me just give you an example. Let's say you wanted to include some personal property in the sale, in the transaction of the real estate transaction. So let's say the buyer wanted to keep the seller's refrigerator. Well, then you wouldn't write seller or buyer retains refrigerator, or buyer refrigerator shall convey at closing, you wouldn't write that in the special provisions. You'd actually get the personal property addendum that's promulgated by TREC to notate that. It's also a good idea to take a picture of it so that you can make sure that you're actually going to get what you want. If you said, I want to keep a patio chair, and there's 3 or 4 patio chairs, then you would just want to make sure you're actually getting the one that you're most interested in. Also, if another document is used, let's say your client insists on some other kind of document being used, you likely won't have the authority to even assist them or answer too many questions or help fill out the contracts, just because the authority given to you through your license, it just doesn't give you the ability to help out with any other contracts. You haven't had adequate training for those contracts, and doing so may be considered practicing law without a license, and doing that could get your license revoked. In the contract, all timelines and deadlines are meant to include all calendar days, not just business days, and it even counts weekends and holidays. So if you got a 5-day deadline and that 5 days straddles a weekend and a holiday, the weekend and holiday still counts against your 5 days.
Unless the contract specifically says that it does not include weekends and holidays. As part of the overview, I want to just show you a few things on the TREC website. So Google TREC 1-4. This will probably be your first result. You click this button to see the most up-to-date version of the contract, and I'll show you how you can verify that here in just a moment. But the first page is a little bit different because there's no address blank at the top, but you'll see it every other page has an address blank at the top of the page. This address blank is here because if a sheet of this document gets misplaced, you'll know that it belongs to this set of documents here. And so all the pages are numbered. The address is on there. You'll know that it belongs in this set. There's an initial at the bottom of every page. And if you scroll all the way down to the signature blank, and you'll see where the signature blank is. And then this is the date where it shows the effective date of the contract. Everything above the signature line is the agreement between the buyer and the seller. All the terms of the agreement are above the signature blank. Below the signature blank are just some pages that are included for ease of use and disclosure, and just to make sure everybody's on the same page as to whether or not the terms of the agreement are followed. So let me show you what I mean by that. You've got the broker information, some disclosure about broker fees, and then you've got the receipt page, and the time and date here are listed so that whenever the escrow agent provides the receipt for this, you'll know right here on the contract whether or not that was delivered within the allotted amount of time to conform to the terms of the agreement. So that's it for that. Let me show you this. The bottom right of every page, you'll see the version number of the contract. In the top right, you'll see a date. This is the date that that version became effective. And all you have to do is take the hard copy of an offer that you've received and compare the date and the version number on the offer that you received to the date and the version number of the contract that's hosted here on the Texas Real Estate Commission website. And if it's different, then you just need to ask the real estate agent or the buyer that submitted that offer to you. You just need to ask them to politely revise the contract or rewrite the contract on the most up-to-date version. And they'll usually do that without a problem. Also, any new changes to the contract will usually be outlined right here on these documents. You'll see this red line version of the contract here. It just shows that anything that was taken out of the contract, anything that was changed, and then you'll see items that were added to the contract. And so it just makes it really easy to be able to identify changes between one version or another. And that concludes the overview of the contract. Let's dive back into this intro.
One final note on how to fill out the contracts. Unless you have a reason to deliberately leave a field in the contract blank, and putting some kind of text in the field is a great way to avoid making errors, even if the text is just NA, which is the abbreviation for not applicable. This also lets other people in the transaction know that you have seen that field, you didn't skip over it, you've given it careful consideration, and it wasn't unintentionally left blank. So, all right, that's it for the introduction and all of the background and overview and everything. Let's go ahead and dig into the next part, which is the nuts and bolts. We're going over the contract one paragraph at a time. Paragraph 1, the parties. The simplicity of this paragraph leads to mistakes. This section introduces you to the parties of the contract, the seller and the buyer. You are not a party to the contract. You're just an agent. We're licensees. We're not an attorney. Our client can do just about anything that they want to do, even if it doesn't serve their best interest. And by the way, it's not up to us to determine what their best interest is. It's up to them to determine their best interest. So just an example is if the buyer insists on talking to the seller, if the buyer and the seller are complicit in that, they're okay with it, then by all means, the agents should step out of the way and let the buyer and the seller talk. As much as that gives me the EBGBs, hey, if they feel like that's in their best interest, then they have full authority to do that. In the first blank, you put the seller's name. Second blank, you put the buyer's name. Use the correct spelling of the legal name of each party. No nicknames, no middle. Don't use the middle name as the first name. You know, if they happen to go by their middle name, put their full legal name. No abbreviations. And find out if they're a junior or a third, or if there's some kind of suffix or prefix you need to include in there. The easiest way to do this is just to ask your client to spell their full legal name for you. And also, the way I write it, I like to write their full names out. I don't like to write Tracy and John Smith. I like to write Tracy Smith and John Smith as a purchaser. I don't know if there's any kind of legal reason for that. I don't know why. I just feel like that's the complete way to do it. So that's the way our company does it. And this is an opportunity for you to head off problems in advance. This gives you an opportunity to verify their driver's license to make sure that their name matches, and that can help you avoid a potential conflict with the notary at closing, because if the driver's license doesn't match the contract and doesn't match the lender documents, you could have a problem, which brings me to the lender documents. This gives you an opportunity to verify how their name appears on the loan documents to ensure that you're not going to have to file an amendment to reconcile the differences between the contract and the loan documents. If the name appears different on each, then you're going to have to amend the contract. Also, don't leave the seller's name blank. If you're the representing the buyer making the offer and you don't know what the seller's name is, try your hardest not to leave it blank. Do everything you can. Look at the bottom of the MLS listing to see if you can find the seller's name there. If you can't find it there, then look at the Central Appraisal District website if you can. And if you need help finding the Central Appraisal District website, just Google CAD and the county name. So for instance, Tarrant, CAD, or whatever. And then also, it would be a great idea just to call the agent and ask them what the seller's name is, and include that question in just your normal standard pre-offer phone call that you should probably be making anyway. One other note here is if there's any kind of question as to how the title should be vested, or the kind of legal structure between multiple parties on the contract, then you might need to specify. So for instance, if you've got two people on the contract, but they're not married, but they're like buying it both as purchasers, then you might need to say something like, I don't know, it'd be kind of weird, I guess, but John Smith, a single man, and Jane Doe, a single woman, or that they're tenants in common, or certainly if it's a company, then you'd want to put the legal structure of the company. So if it's a corporation or an LLC, make sure and include that. If you're the listing agent, then this is a good opportunity for you to just verify and make sure that there isn't anything weird going on with the ownership. If the husband and wife are not talking to each other, sending you mixed signals, you might want to just check and see if they filed for divorce or something. I don't know how you have that conversation, but just find out if there's anything weird going on with the ownership, any deaths that have happened, if you're selling it out of an estate, anything that could fracture the ownership somehow. If there's multiple buyers or sellers and for some reason they won't be able to be present at the same time for closing, then find out now so you can start working on getting a power of attorney together. And because sometimes it takes a little time to get the power of attorney approved by the title company or the buyer's lender. So it's good to find out about that ahead of time. And a side note, just for the investors, If you want to put something like and or assigns, you think you might assign the contract, there's really no need to put and or assigns on the contract. All contracts are going to be assignable unless they specifically say that they're not assignable. But I don't believe our company is going to be dealing with any contract assigning anytime soon.
Paragraph 2 is the property. The purpose of this paragraph is to define what the buyer's agreeing to buy and what the seller is agreeing to sell. It tells you what's being conveyed in the purchase, what's going to be delivered upon possession, and it's not just fixtures. It's not just the real estate and the land and the structure. There's far more to it than that, and it also defines what's not being conveyed, and it goes way beyond real estate. So there are 5 parts to this paragraph, but I want to tell you, you need to know that this is a definition. So what it means is the word property is not going to be defined by the common definition that you would find in Webster's dictionary. The definition for the word property in this contract is defined in paragraph 2. So anytime you see the word property throughout this contract with a capital letter P, what it's meaning is that it's referring to what's defined in this section. Okay, there are 5 parts. There's the land, the improvements, the accessories, the exclusions, and the reservations. And let's go through each one of these sections one at a time. Paragraph 2, section A is the land. The land is the dirt, but it's more than just the dirt. It's the dirt, the property, everything that's included in the property itself. It's whatever's being sold within the property lines and the property boundary lines. And you'll know exactly what it is by, and the way you measure that is through getting a survey through a surveyor. And so that surveyor will draw the property boundaries and they'll show you where easements are and that sort of thing. But you have to be able to identify where this property is, and there are 2 different ways to identify that. There's the legal description and the known as way. And the known as way is how we know it as, and that's just through the address. That's what the Postal Service goes by. That's what 911 goes by, and that's what Google Maps and everybody that you and I, when we refer to a piece of property, it's the known as way. And then there's the legal description. So the legal description is a much more specific, unique description of where that property is located. And there's 2 different ways that you can, 2 different formats of the legal description that you'll find. There's lot and block, and then there's meets and bounds. Lot and block is what you see right here in the contract where it says lot blank, block blank, and in the blank edition, city of blank, county of blank. That's the legal description. Meets and bounds is different. It's usually like, I haven't seen too many meets and bounds, but it would be like 10 paces past the tree stump and you twirl around 3 times and it's over the, where the big boulder is. It's just a description like that, but it's a very specific description based on immovable permanent objects where you can clearly define exactly where the property boundary lines are. And this contract is not a valid enforceable contract unless it has that legal description on here, because you have to have a reasonable amount of certainty of what it is that you're buying and where that property is located. And so you have to have a legal description on here. But if you have a legal description that doesn't fit in the blanks, what you've got to do is continue writing that full legal description out so that it'll be a legal contract, and you can do that in the special provisions. That's a perfect use for the special provisions, or an attached sheet of paper. Here they say an attached exhibit. So if I was going to attach an exhibit with an extended legal description on it in the special provisions, I might say see attached exhibit A for full legal description. There are 2 places that you can find this legal description. One is usually at the County Appraisal District website. They usually list it on the account page. They'll have the legal description, but if it's a long one, then you're not going to find it all listed out there. Some of these legal descriptions can be a page long. So the other place you can look is go to the county clerk's office and look at some deed records and find an old deed, and they'll do that same exact thing. They'll say, see attached exhibit A for the legal description. So you can pull that out and read the whole legal description. One way or the other, that has to be included for this to be a valid contract. Paragraph 2B is the improvements portion of the property or real estate, and it includes everything that you might expect. It's the house, the garage, all the fixtures, things that are screwed in, affixed to the property, permanently installed built-in items, appliances such as the oven or the dishwasher, not necessarily the refrigerator because it's not screwed into the property. That's not an improvement or a fixture, but you do have things like carpet, mirrors, ceiling fans, attic fans, mailboxes, TV antennas. Now, something that's new on this list are the mounts for brackets for the television, speakers, that sort of thing. Of course, you have the HVAC system, heating, air conditioning, security system. It goes on and on. One thing that changed in this paragraph is that it used to say only items that were owned by the seller. They have since struck through that, and so now it's not restricted to just items that are owned by the seller. And you might think that that's odd at first. Well, how can somebody sell something that they don't own? Well, it happens all the time. For instance, easements. You have utility companies that own the power lines in the ground. Well, that house is sold all the time. The power lines are not going to be removed when you sell the house, obviously. That kind of went without saying. But items like solar panels or satellite dishes where another company might own them and they're being leased, that's still going to be conveyed with the property. And so here it defines all of that stuff as part of the improvements. Real property, real estate, fixtures, that's what we're all accustomed to. That's all part of the improvements. Paragraph 2C is for accessories. Now, this was shocking to me because I wouldn't normally think that these items are part of the property, but it's certainly not real estate. A lot of these items are personal property or it's digital property, but here's what it is. This is talking about window air conditioning units, curtains and rods, window shades. Now, here's the part that was kind of shocking and relieving to see that door keys, mailbox keys, pool equipment, fireplace logs that could easily be removed, and it even touches on security systems that are not fixtures. So if it's a security system, even if it's not screwed into the property, it has to stay with the property. I had a deal that had a dispute over that exact issue. Garage door openers and on and on. So if you buy a house and they don't give you the garage door openers, they're violating the contract. And then this next section is a new addition. It talks about the controls that's included in the seller's transferable rights for its software controls, applications used to access control improvements or accessories, hardware used solely to control improvement or accessories. This is for smart items such as a Nest thermostat, Ring doorbell, those kind of items. They might have passwords, digital manuals, things that might need to be conveyed, instructions that need to be conveyed, or maybe a link to an app or something. I'm not sure what all could be included here, but this specifies controls. And so this is the first time that this digital property has been addressed in a real estate contract. This is the first time in this contract. It's going to be touched on in paragraph 4 and also in paragraph 10. And anytime it's talking about the word property, it now includes these items. The fourth section of paragraph 2 for property, it's 2D, the exclusions. This is where you talk about what you don't want to be conveyed whenever the buyer takes possession of the property, what's not being included as part of the sale. And so if there's something in the accessories area or the improvements area that you don't want to convey, then you need to write it in this section. And if you run out of room, then you can continue in special provisions. But things like rose bushes, I've seen that come under dispute. If you want to keep the rose bushes or the curtains and rods, that sort of thing, then you have to put it in the exclusions area. Finally, section E it's 2E, reservations. This says exactly what I just said. Any reservation for oil or gas or minerals, water, timber, any other interest made in accordance should be made with an attached addendum. So it's just saying don't try and reserve the mineral rights for the seller using this paragraph. Get the addendum, silly.
Let's talk about paragraph 3. Paragraph 3 describes the sales price. And it also begins to describe the kind of financing that's going to be used to purchase the property. So the way that it works here is line C is the total sales price. That's going to be the number that the seller cares the most about because that's the amount of money, that's the total purchase price. That's the amount of money that the seller is going to actually receive. What this contract does is it divides it up so that the first line here, line A, that's going to be the down payment amount. Line B is going to be the amount financed, the loan amount, and then you just total those together to get line C. So, and A plus B is always going to equal C no matter what. So if you've got a deal where there's no down payment at all, zero down payment, then in line A for the cash portion of the sales price, there's no down payment, so there's no cash. So you would put 0 on that first blank there on line A. Line B would be the total financed amount. Well, if there's 0 down payment, that means the entire amount of the sales price has to be financed. Let's say it's a $100,000 sales price. That means that $100,000 is going to have to get financed, so $100,000 goes in line B. Line C will be the total sales price. In this case, it's going to be $100,000 because 0 was the down payment, $100,000 was the financed amount in line B, and then so line C is $100,000. Same thing would happen if it was a cash deal, only it would be reversed. So if no financing was taking place, if the buyer was using just total cash to buy the house, then all of the entire sales price would be in cash form. So in that same example, $100,000 would go in line A. There would be no financed amount, so line B would be blank, or you'd put a 0 in there, and then line C would be $100,000. Okay, all that stuff is the same as it used to be. The only thing that's really different here in paragraph 3 is on line B, where it's talking about the financing. You have 3 different options. This gives you the option to select the type of financing that's going to be used, and it references an addendum that's going to correspond with that type of financing that you need to attach to the contract that describes that type of financing in detail. So the one that you're going to use the most of, and it's going to happen on almost any transaction that it contains financing, like a mortgage, you'll have to check this box that says third-party financing addendum. We're going to get into detail on that third-party financing addendum in a different video. For the purposes of this, all you're going to need to do is just make sure you understand third-party financing means any type of financing that is from a bank or from a third party, if it's from mom and dad, if you're getting a loan from mom and dad, if you're getting a loan from Joe Bob at church and he's got a bunch of money and he wants to lend it to you so you can buy a house, or if you're going to Wells Fargo or Bank of America or one of those typical conventional regular lenders, then you're going to check third-party financing and make sure that third-party financing addendum is filled out completely. One last word on this paragraph is that if something happens in the course of the transaction where you go and have to amend or you negotiate the purchase price, that's done fairly often. And so if you change the purchase price and amend that in the contract and the buyer's using some financing, make sure that you also amend the financed amount, okay? It's because what's going to happen is there are certain protections that the buyer is given that are spelled out in that third-party financing addendum, and if you don't amend the financed amount to make sure that matches up with the third-party financing addendum and to reflect the new changes of whatever the negotiated new changes are, then you may lose some of your protection there that third-party financing addendum offers. So that is it for paragraph 3. I'm going to move on to paragraph 4.
Paragraph 4 is all about leases, but it hasn't always been this way. A previous version of the contract had paragraph 4 listed as the licensee holder disclosure, meaning if you're a real estate agent, you would disclose that in the contract in paragraph 4, but no longer. It's been changed as part of a new version of this contract. Now it's all about leases, and there are 3 main parts to this section. There's residential leases, fixture leases, and natural resource leases. And then inside of the natural resource leases, there's 2 subsections, and we're going to cover every bit of it right now. It starts off by saying, except as disclosed in this contract, the seller is not aware of any leases affecting the property. And you might think, how in the world could a seller not be aware of a lease affecting the property? Well, there may be a situation. For instance, what if somebody inherits a property and they didn't know that there was a lease signed on a mineral rights or maybe on the solar panels or something like that, and they inherited the property and they weren't aware. There certainly are situations like that, maybe, where somebody isn't aware. So they're not going to be held responsible, and if they do know of a lease, they have to disclose it in this contract. There's something else in here that is interesting. It says that the seller may not, without the buyer's written consent, create a new lease, amend an existing lease, or convey any interest in the property. Now, this last little bit, convey any interest in the property, actually seems kind of out of place to me. It was moved from a different part of the contract into this, and this is part of the new revision of this most updated version of the TREC contract. So you're not allowed to convey any interest in the property if you are a seller unless you're disclosing it to the buyer. And that seems like obvious, but there are investors out there doing all sorts of crazy things, and it's good to see that that's prohibited. The real purpose and reason that this paragraph was added to the contract is because it forces and allows earlier disclosure of these kind of issues and avoids last-minute crises at the closing table. Because in the past, what would happen is the title company representative or escrow officer, they would ask the seller, hey, are you aware of any kind of leases or whatever? There was a document they had to sign called the Affidavit of Debts and Liens, and the seller typically just wouldn't even think about these kind of things until they're sitting at closing. They're like, you know what, I think we are under a lease on those solar panels and the water softener and the propane tank and on and on and on. And so then the title company, they understand that those items, even if the seller isn't aware of a lease involved, that sometimes there is a lease that presents a complication, and so the title company would oftentimes put the brakes on the deal. They would go, stop closing, contact the vendors, get copies of the leases, and it causes a huge headache right there at the closing. If this was just identified earlier on in the transaction, then we don't have those kind of crisis moments. And so now there are addendums specifically for each of these types of leases, so we can learn more about them up front. You may need to take a class or dive a little deeper on those addendums to understand a little bit more about them before you start using them. But that's one of the main reasons why this paragraph is in existence. And here's just a little tip. Ask for a copy of all the leases before you sign the contract if you're a buyer. And ask if they're receiving any royalties on any leases. These are items that are great to know about before you get into the contract, because it could mean that there's extra income or an extra obligation expense that you will be contracted to inherit if you buy this property. Also, remember in paragraph 4 when we were talking about the definition of property and how they just changed the definition in paragraph 4? And so here's one of those instances where the word property shows up and it's capitalized. So now what is included in these leases are those items that are smart home features, the security systems, software, controls, those kind of things are now included in this. And so it's part of the property. Anything affecting the property, leases affecting the property, now included in this area. The first subsection is residential leases. 4A is residential leases. And so this is the typical type of lease a rental property would have, where you're leasing to a tenant. This isn't something that has to do with hunting lease. This hunting lease is more like a license. It's not what we're talking about here. This is a residential lease. It's just saying that there's going to be an attached addendum that will go into more detail about that. But here's where you disclose that that's going to happen. Paragraph 4B is fixture leases, and this is what we've been talking about, alluding to as part of the property. This is for specifically solar panels, propane tanks, water softeners, security systems, that sort of thing. And this is just saying there's an addendum regarding fixture leases. And again, a fixture is just something that's affixed to the property, something that's screwed into the property. If you turned the property upside down and shook it, it was not going to fall out. So any leases concerning those types of items. And the last section is 4C, natural resource leases. This is a category that includes oil and gas, mineral leases, water, wind, other natural resources. And the subsection here gives you two options. It says that the seller has delivered to the buyer a copy of all the natural resource leases, or the second one says that the seller has not delivered a copy to the buyer. And it also says that the seller will provide the buyer a copy of the lease within 3 days after the effective date. And it gives the buyer the ability to terminate the contract within blank number of days after the buyer receives the lease. So this is one of those situations where if you're a seller, it really is much better to select that first box, because as a buyer, if I'm looking for a way to get out of this contract, then I'm going to hope you didn't send me a lease, and I'm going to hope that there is some kind of lease there, and then I'm going to put some kind of really absurd number of days in this days blank if I'm just trying to get away with something. And so what if I put 20 days in here, that now I've got 20 days to back out of the contract if you didn't deliver it, or if you didn't deliver it before we got under contract, then you have to deliver it within 3 days. So I'm going to want to make sure my option period is at least longer than 3 days, and then I may give myself a little bit more room to get out of the contract. So there's something here that could affect either party. As a seller, provide it up front. As a buyer, I really want to get into a deal knowing what I'm getting into. So I'm going to hope that I get that up front, and if they don't give it to me up front, I might angle to have an out here that's extended beyond any kind of other contingency, just in case there's something goofy going on in that paperwork. I think it's important to note here that not all clients will need the same level of explanation. If you have a client that is very technologically savvy, they're up on all the newest gadgets and gizmos, they'll probably understand a whole lot more about how to handle leases and passwords and software instructions for smart home items. But if you're dealing with somebody that's not quite as familiar with technology, you may need to take another moment to dive deeper into this paragraph and everything that it means about how to convey the credentials to log into different things, passwords, and that sort of thing. Paragraph 5, the earnest money and termination option. Oh man, this is action-packed. They took 2 paragraphs from the old version of the contract, and on this version, when they changed it, they combined both of those paragraphs, and they were 2 of the most impactful paragraphs of the whole contract. So this one is just full of action. There are 5 main sections in this paragraph. The first one is the delivery of the earnest money and option fee. So I think it actually should be called the earnest money and the delivery of the earnest money and option fee, but whatever. There's 4 sections inside that one. Then B is the termination option. That's the old paragraph 23 in the last version of the contract. Now it's just B. Then you have C, which is the failure to timely deliver the earnest money. D, the failure to timely deliver the option fee. And then E, just time itself. All right, so we're going to dive into this thing, but the reason they did this is because the last contract created all sorts of problems and confusion. It was insane. There were 2 separate checks that the buyer had to deliver. It was made out to 2 different people, 2 different sets of timelines. They maybe even accepted 2 different forms of payment. It was super confusing. Who could sign on behalf to say that they had received it was not clear. The timelines weren't clear. And what would happen if these things didn't occur as prescribed was all just a muddy mess, and it just resulted in a bunch of confusion. And now it's very simple. There's 1 check, 1 place, 1 timeline, 1 everything. These 2 paragraphs were hashed over extensively in order to make this. It's pretty bulletproof because they went through many versions before they finally passed it and included everything in this big old beefy paragraph 5. Let's get into it. I'm excited. 5A, delivery of earnest money and option fee. Here it says that within 3 days after the effective date of this contract, the buyer must deliver to blank as the escrow agent at blank address a certain amount of money as earnest money and a certain amount of money as option fee. The earnest money and option fee shall be made payable to the escrow agent and may be paid separately or combined into a single payment. Hallelujah, that makes life easy. Here we go. So the first blank there is where you find out where the title company is, or which title company it is, and then the second blank is where that title company is located. So that's the area where you list out who the title company is. The next blank there is the amount of money for the earnest money. Now, I'm going to explain more about what the earnest money is here in just a minute, but I want to tell you how much to put in the blank. First of all, it could be any amount, including 0. It doesn't have to be any amount, but it could be any amount. You could put $10,000, $100,000 in there. It just doesn't matter. This is a deposit to show that you are serious, and I'll go into more detail about that here in a minute, but the seller is typically expecting about 1%. So if you got a $300,000 house, $3,000. $500,000 house, $5,000. But the more money you put in it, the stronger your offer is. The less money you put, the weaker your offer is. Same thing kind of goes for the option fee, except for, as we're about to learn here in a moment, the option fee is a much smaller amount. I've seen it hover around 1/10%. Again, it could be anything, but it's not intended to be a large amount of money. So let's say, $400 for a $400,000 house. That's about right. I have seen some people just put $100 in the blank, no matter what, no matter how much the house is worth. But I'm a fan of 1/10%. And so let's just dive in. We'll cover every other section of this paragraph. 5A1 could be a little confusing if you hadn't ever read it before and if you're just skimming over it and don't know what this is for here. But it says buyer shall deliver additional earnest money of blank to escrow agent within blank days after the effective date of the contract. And you're thinking, well, didn't we already talk about earnest money? That's right. There's one key word in this that changes it a little bit, and it's the word additional. So we've already established what the earnest money is going to be, but if you want additional earnest money at possibly a later point in the contract, then you can list that out here. I've seen this utilized with builders pretty frequently. As the construction of the house is being built, then the value of that house is actually going up over time, and the commitment level of the seller is going up. So the seller will sometimes want additional commitment from the buyer as you continue into contract. And that's when you'll see that listed out there. What goes in the blanks is just anything you can dream up, anything and everything. This little section is not used very commonly, so let's move on. 5A2 says, if the last day to deliver the earnest money, option fee, or additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest option or additional earnest money as applicable is extended until the next day that is not a Saturday, Sunday, or legal holiday. This is pertaining to the very first number in this paragraph. Within 3 days after the effective date, buyer must deliver to blank. All right, so it's within 3 days. So what this means is if the contract was executed on the 11th, then you got to count 3 days after the effective date. The effective date would be the 11th, so that means the 12th would be 1, the 13th would be 2, and the 14th would be 3. Now, if all three of those dates are not, or actually all we care about is that last date. If the 14th is not a holiday or a weekend, then the 14th is when that has to be turned in by. But if the 14th was a weekend or holiday, then it would just roll over to the next day. So like if that 14th was a Sunday, then it would be due on Monday. Or if the 14th was a Monday and Monday happened to be a federal holiday, then it would roll over to the Tuesday. You might be asking yourself, well, what time on that third day do I have to have it turned in by? And my answer is, I don't know, and I don't really care unless I'm the buyer and I'm trying to get that money out there, or the buyer's agent maybe. Here's what we have to deal with. We have to deal with the title company, the escrow agent, and their operating hours and when they're willing to receive it. I can guarantee you that there's not going to be anybody at that title company at 11 p.m., but it's not really my problem. I would say that it's kind of depends on the company policies of that title company as to how late they're going to be willing to receive that. And the main thing I'm going to be concerned about is when it is receipted by. If the receipt on that is done in the appropriate amount of time, then it's all good. And I want the title company handling money because that's what they get paid to do. They're experts at handling money. They're shuffling money around all day long, a lot of money from banks and rich people and just tons and tons of money to buy and sell these houses. And so they'll know how to handle it. This is a lot more cut and dry. It was a whole lot worse when we had to depend on people that were not a financial institution to provide that receipt. Paragraph 5A3 is smart, and I like it, and it would probably bother me if I was on the wrong side of the fence, but I think this helps avoid a lot of conflict, and I'm going to tell you what this really means later on, but here what we have. 5A3 says, the amount the escrow agent receives under this paragraph shall first be applied to the option fee, then to the earnest money, and then to additional earnest money. So if the option money is supposed to be $300 and the earnest money is supposed to be $3,000, then there's a total of $3,300 that should be delivered to the escrow agent or the title company. And just like this contract says, it can all be in one check. So you could deliver one check and it could be short. So let's say, what if the buyer delivered $3,200? then the first $300 of that $3,200 check is going to go towards the option period. And then the rest is going to go towards the earnest fee. And that earnest money is going to be $100 short. So then what happens? Well, we're going to find out as we continue through this paragraph. It gets kind of interesting. Paragraph 5A4 says that the buyer authorizes the escrow agent or the title company to release and deliver the option fee to the seller at any time without further notice or consent from the buyer, and they release the escrow agent from liability for delivering the option fee to the seller. And the option fee will be credited to the sales price at closing. In the past, you used to have an option. Would you like the option fee to be credited to the sales price or not? And you had that option. Well, hardly anybody checked the not button. And so it's always applied to the sales price at closing usually. And so they just made it part of the hard language of the contract. Now it's always applied to the sales price. But so if you don't want it applied to the sales price, you have to specifically say something to change that. All right. That's one part. And then the second part of this is talking about that the title company, escrow agent, can deliver the option fee to the seller at any time. So here's the deal. If the buyer writes a check for the option period, then the seller's going to get that money no matter what, even if the buyer backs out. So the contract says the seller can get that money at any time. They don't have to wait for the deal to close. They can get it in advance. And my only advice on that is if the seller wants to get that money before closing, you need to ask for it several days before closing because they're drawing up all the final paperwork. And if you say, oh, darn, I want to get my $500 option fee and it's 2 days before closing, then that's going to foul up all the paperwork and cause a delay. Okay. And there were situations where some title companies were a little reluctant to release any kind of money because if there's any kind of dispute as to who should get that money, when and where, and that sort of thing, then the title company could be in trouble. They might risk some liability if if there's any kind of disagreement on who should get that money. So in a lot of situations, the title company would ask every single person in the transaction, buyer, seller, realtors, broker, who knows, they'd ask everybody to sign a sheet of paper saying, we all agree this person should get the money and here we're going to sign it. And as long as everybody has unanimous consent on that, then the title company would release it no problem because they know there's no conflict. But they want to hear from everybody on that. And this is saying that for the option fee, the title company can release that money, everybody agrees, and we won't hold the title company hostage, or you won't give them, we're releasing them of liability if we disagree with that. So this just makes life smoother, easier, and allows transactions to happen without litigation. Let's move on. The big juicy termination option. This is paragraph 5B. The termination option is designed to allow the buyer to back out of the contract, and it only costs them a little bit of money. And so let's read what this says. It says for nominal consideration. So it's designed to be a very small fee. There's a lot of power in this fee. It gives the buyer to back out with relatively little risk, and the seller does not have the ability to back out. It's a very leveraged position. The seller has no choice but to stay in that contract, but the buyer can back out as long as the buyer backs out within a prescribed amount of time. And that's what that first blank is right there. We'll get to it. So for nominal consideration, the receipt of which the seller acknowledges and the buyer's agreement to pay the option fee within the time required. Seller grants buyer the unrestricted right to terminate. That means they can terminate for any reason or no reason. It says they can terminate this contract by giving notice of termination within blank days after the effective date of this contract. And we're calling that the option period. Notices under this paragraph must be given by 5 p.m. local time where the property is located by the date specified. If the buyer gives notice of termination within that time, then a couple things are going to happen here. Number one, the option fee will not be refunded, and the escrow agent shall release the option fee remaining with the escrow agent to the seller. And number two, any earnest money will be refunded to the buyer. So the seller gets the money, for the option fee, and the buyer gets the money for the earnest. And that's what happens here. So this is just saying the buyer can back out of the contract as long as they back out within a certain number of days. And you might be wondering, well, how many days should I put in the blank? Here's my answer. It's whatever you want, but it needs to make sense. So anything less than 5 days is just setting yourself up for trouble. But people like to be really aggressive with this because right now we're in a hot market where buyers need to make their contracts as appetizing as possible and very appealing. So they like to put a short number of days in here to make it look like they have a high commitment level. They're going to go through with the deal. They don't want to back out, but they want a few days to do something. Well, if you put a short number of days in here, it does make the contract appear stronger. However, if you're trying to get an inspection done during that option period, then you need to make sure that you've got enough time to coordinate schedules with the inspector. So that's one hairy variable we got to look out for. And then not only that, you probably want to get the results of that inspection back before the deadline, and you probably want to leave yourself enough time to negotiate repairs. That's another one. And so let's just imagine, what if you're the buyer, you get the inspection done, you send over a repair negotiation to the seller, then you need to leave enough time for that seller to respond to you. Because what happens if you run up on your 5 o'clock deadline on the day that option period is going to end, and it's like 4:30, and you're thinking, darn, if I don't hear from these guys and they don't accept my offer, my negotiation, then I'm stuck with this property in as-is condition. Don't count on benevolence. If you don't have something in writing saying your negotiations are agreed to, then that 5 o'clock deadline passes, and if you still have a valid contract, you can't back out unless you go into default, which is paragraph 15. So you need to allow enough time you need to allow enough time for the seller to respond to your repair negotiations and allow you guys to come to an agreement before the buyer comes up on that 5 o'clock deadline and starts to panic and just decides to back out of the contract because they don't want to get stuck. Okay, so that's the danger of putting an option period in there that's too short. If you put an option period in there that's too long and I'm the seller, I'm going to wonder, what in the world are you thinking, and why do you need so long of an option period? Now, the more money you pay, the more time I might be willing to give you as a seller. But if you put anything longer than 7 days in there, I'm going to be asking why. Okay, so I wouldn't put anything shorter than 5. I wouldn't put anything longer than 7 unless I have a good reason to. And certainly anything is negotiable, but I'm going to want an explanation either way, and I'm going to want to acknowledge the risk of doing it too short because I don't want to just enter into a contract and get stuck and somebody bail out. Here's something that a lot of people don't think about. Do you have to have an option period in order to do an inspection? What do you think the answer is? The answer is really no. You don't have to have an option period in order to do an inspection. The inspection is, that's in a completely different paragraph. But if you want to have some leverage for negotiations, to negotiate some repair items as a result of that inspection, then you definitely want to get your inspection done during the option period. That way, if you don't agree to terms after the results of that inspection comes back, then you have the ability to back out. Now the fun part. What happens if you don't deliver the money on time? So this really relates to a timeline and the amount of money. So let's dig into paragraph 5C. It says the failure to timely deliver the earnest money. If the buyer fails to deliver the earnest money within the time required, the seller may terminate this contract or exercise the seller's remedies under paragraph 15, which is the default paragraph, or both, by providing notice to the buyer before the buyer delivers the earnest money. So it says failure to timely deliver the earnest money. If you don't deliver the earnest money on time, this is not just saying like half of it. This is saying this is all of it. If you're $1 short, then you haven't delivered the earnest money. So that there's an amount there, and then there's a timeliness to it. So the money has to be delivered in time, and it must be in full. And if you don't deliver all of it, then the contract can terminate. So you don't have a deal. Now, this is kind of funny. It says by providing notice to the buyer before the buyer delivers the earnest money. So what if the buyer delivers the earnest money, but it's after the 3-day effective date? What if they delivered on day 5, but and then the buyer gives notice on day 6? Well, if the buyers delivered that earnest money on day 4, then this reads to me like the seller can't provide a notice to the buyer, because the seller provided the notice on day 6, but the buyer delivered the money on day 4, even though it was required on day 3. I think we still have a valid contract. Anyway, I don't want to be the guy to test that, but it is real interesting that they put the word before the buyer delivers the earnest money. So the buyer delivering the earnest money seems to be the deadline on when the seller would have to send a notice in order to terminate the deal. So if you're a seller that wants out of that contract and the buyer hadn't delivered the earnest money, you better be ready at 5 or whatever. As soon as you can deliver, as soon as you know they haven't delivered that earnest money, you send in that notice. The next paragraph, 5D, failure to timely deliver the option fee, is a completely different consequence. It says if no dollar amount is stated in the option fee, or if the buyer fails to deliver the option fee within the time required, the buyer shall not have the unrestricted right to terminate this contract under paragraph 5. So if there's no dollar amount in the option fee, it's just because the buyer didn't want an option period. There's no requirement to have an option period at all. If the buyer wants this contract to convey to the seller that they're very serious and they are comfortable not having any contingency and getting out of this contract, at least the unrestricted right to terminate, then they don't have to have an option period at all. And that's perfectly acceptable. But that's totally different than what if the buyer didn't deliver enough money in time, then they don't have the ability to back out. So that's kind of that would be rough if you intended on having an option period, but then you didn't get an option period, and now you're stuck under the obligation to purchase a house without any ability to back out, and you fully intended to have the ability to back out. Now you got to buy a house. Wow, that's a huge consequence. Let's reflect for a moment on what happens if you don't deliver enough money. Now, if you remember, in the first part of this contract, it says that you can deliver both the earnest money and option fee in one check. And so now that leaves the title company with a dilemma. If you get one check and it's not enough money to cover both the earnest money and option fee, then which one do you apply it to first? Well, according to 5A3, it says it needs to be applied first to the option fee, then to the earnest money. So what that means is if you don't get enough money, let's say you got $3,300 that needs to be paid because $3,000 of it's going to go to the earnest money and $300 of it's going to go to the option fee. But what if they only pay $3,200? Well, guess what? The first $300 of that's going to go to the option fee. So that option fee requirement is going to be satisfied. Therefore, you have an option period. The only problem is you're going to be $100 short on the earnest money, so you're not going to have a valid contract. So your option period is useless to begin with. So what that means is if you don't provide enough money, you don't have a valid contract and you don't have an option period. But so you're not going to get to buy a house. You got to get that money in really quick. As long as you get the additional money in within 3 days, you're going to be just fine. But let's just imagine if the reverse were true. What if the title company was required to apply the money first to earnest money and then to option fee? Well, then what would happen is the buyer would be obligated to buy a house with no ability to back out. So the consequences of the first one, which is the reality of the situation, what the contract mandates is you don't get to buy a house, but you're no worse than you were 2 days ago before you made the offer, or 4 days ago before you made the offer. In the second scenario, if this contract were written differently, where if the money would be applied to the earnest money first, then you would be obligated to buy a house without the ability to back out, and that would be devastating. So you just need to make sure you understand the implications here. If you don't deliver enough money, then you got problems. Now, let's look at 5E. It's time. It says time is of the essence for this paragraph, and strict compliance with the time for performance is required. And that makes sense to me. I get that. What I don't understand is, what does that mean for the rest of this contract and all the other timelines? Does that mean that time is not of the essence unless it specifically says time is of the essence? That's what it seems like to me. So then what happens if we don't close on time? Or what happens if there's some other deadline in this contract that isn't adhered to? I mean, we've got deadlines all throughout this thing. Well, I think what it means is everybody needs to go ahead and still get all their obligations taken care of within the terms of the contract, but we need to give everybody a reasonable amount of time. And so it might allow some wiggle room if there was some kind of unforeseen, super serious, like legitimate excuse. For instance, I got in a car wreck today, so here's my emergency room papers, and so and my right hand got chopped off, so I had to figure out how to sign this document with my toe or something like that. I think that we can give you a few hours to recover from that. And if you were to the other party try and back out or sue you for specific performance, or sue you for not upholding the obligation of the contract because you had to figure out how to sign the contract with your toe, that's not very reasonable. And so the court would be like, hey, wise guy, this isn't cool. Otherwise, if it said time is of the essence, I think it doesn't even matter. Time is of the essence. So if you go past this date, deal's off.
Paragraph 6, title policy and survey. This paragraph begins on page 2 and it doesn't end until page 4. It's pretty lengthy. There are 5 sections in this paragraph. Section A is the title policy, B is the commitment, C is the survey, D are objections, and E is the title notices section. So let me just describe what a title policy is real quick. It's actually would be more accurately called a title insurance policy, since that's what it really is. This is insurance that protects the homeowner and the lender against financial losses from defects in the title. It ensures that you're actually buying the property that you think you're buying. It's so that the money that you're paying, so that you'll know that that money is actually going toward ownership, and that the seller actually had the right to sell the property, and they're actually selling the entire property. And so it really just ensures that the homework that the title company did in researching the chain of ownership was good, accurate homework, and there wasn't something that they missed. If there was something that they missed, or somebody files a lawsuit staking claim to the property, then that's where the title insurance would come into play. But just like any, quote, good insurance, there's going to be exceptions to the coverage. Just like the old style of health insurance, there are pre-existing conditions that aren't going to be covered, and there are certain things that might be considered maybe too risky that aren't going to be covered, and things that just don't make sense that aren't going to be covered. And so that's what numbers 1 through 8 here go into detail on, are the exceptions. So let's just back up for just a second and talk about the practical application of this paragraph a little bit more. Okay, first line, it says that the seller shall furnish to the buyer at the seller or the buyer's expense one of these policies. The seller is usually who is negotiated to pay for the title policy in most traditional transactions, and but the buyer certainly can. The title policy cost is going to be somewhere in the ballpark of about 1%, and I'm sure if somebody from the title company is listening, they would probably just kind of cringe at the thought of me saying that, because that is actually a pretty horrible estimation. It gives you some kind of general ballpark, but the best way to find out the actual cost of the insurance is to go to the title company's website that's issuing the insurance, and they usually have an automated calculator where you can go in and plug in your numbers and determine the actual cost of the title policy that you're going to get. It's the best way to do it. It's what we do for all of our sellers. And then so here's this next blank. This is for you to put in who the title company actually is. You're probably going to use the same exact title company that you use in the earnest money blank. I haven't ever seen an exception to that, but so you're going to use the same title policy. That company is issuing the title policy, and usually the seller is going to pay for it. So let's get down to number 8 here and talk about one of the exceptions, one thing that isn't covered in the title policy, and go into detail about some of the options you have for this paragraph. Before I go into number 8 too much, I need to talk about what a survey actually is. A survey is a sketch of the property lines and boundaries, and of the easements on a property. It shows how much property the purchaser is buying. And so normally errors on the survey are not insured by the title policy because of it's an exception to the coverage. So number 8 allows you to insure against errors on the survey. So where this would come into play is if you're not actually ordering a survey. If you're using an existing survey, then the surveyor who drew that survey, they owe you no obligation because you weren't their client. You didn't pay them. Whoever paid that surveyor was guaranteed a certain quality of work by the surveyor. And so if there was an error, that surveyor would probably cover it. He probably had at least errors and omissions insurance or something that would cover any errors made on that survey. So if you're not getting a new survey, then it's really a good idea to go ahead and get this coverage. If you are getting a new survey, then you are going to be that surveyor's client, and so there are going to be extra protections in place. And so there may not be as strong of a reason to get the insurance here. So you can either amend the exception to say that it would cover shortages in area. In other words, if the surveyor drew the line a little too far in and it shorted the homeowner of land that the homeowner really wanted, then it would cover an error like that. And then you can say that the buyer or the seller pays for that insurance. Either way, it doesn't matter. The cost of the insurance is going to be anywhere from 5% to 10% of the cost of the insurance policy, the title insurance policy. So just for instance, if the title insurance policy is about 1%, then the cost of this is going to be somewhere in the ballpark of 5% of 1% of the title policy. It's really not much money. It's a good idea to get if you're using an existing survey. All right, section B here is the commitment. What this really is the title insurance company's commitment to insure the property under certain, or insure the title under certain conditions. And since they can't actually provide the insurance until they get paid, the insurance doesn't kick in until closing, but this is their commitment to insure it. And so the title commitment is a document it's several documents that shows everybody under what conditions they're willing to insure the title. And the conditions are their covenants, meaning their promises to insure it, or their conditions or restrictions that are going to limit their coverage. And they have to deliver that bundle of paper to the buyer within 20 days of receiving the executed contract. Okay? And the place that they're going to deliver that bundle of paper is going to be to the address, the contact information that we're going to list in paragraph 21, which is where we're going to list the purchaser's contact information for all the notices to be sent. So if the title company doesn't send it in time, then they've got all sorts of little ways that they can extend it. They can extend it up to 15 days or 3 days before closing. And if something happens and for whatever reason they're just not able to issue a commitment, and nobody's really preventing them from doing so, then the buyer will have the option to terminate the contract and earnest money will be refunded to the buyer. I've seen it happen on like foreclosure type deals where there was some kind of weird ownership chain there, but I haven't ever seen that a deal not go through on just a traditional sale. Section C, the survey. Okay, this is actually a pretty interesting section here, and I'm going to just nerd out on it a little bit. First, let's hit up the easy sections first, the easy options. You've got 3 different options to choose from. Option 3 says that the seller's going to pay for a new survey. Option 2 says the buyer's going to pay for a new survey. And then you've got to select how many days they have to deliver the survey. The title company is almost always going to be the one to actually order the survey. And the box that you check here, either 2 or 3, that's going to depend on whose side of the settlement statement the fee ends up on. So I just want to make sure that the survey is not ordered prematurely. The survey is going to take maybe about 5 days to complete. You want to make sure you get it at least 5 to 7 days before the closing date. But you want to make sure that you're not ordering it inside the option period, because if the deal falls apart, you don't want to have that extra expense hanging around. So you just pick your date there according to those parameters. Okay, so let's just go back up to the top, and I'm just going to read through this and kind of nerd out on it. Okay, The survey must be made by a registered professional land surveyor, no problem, acceptable to the title company and the buyer's lender. Okay, so it's got to be acceptable to the title company and buyer's lender. All right, let's say that we're checking box number 1. Within blank days after the effective date of this contract, the seller shall furnish to buyer and the title company the seller's existing survey of the property and a residential real property affidavit promulgated by the Texas Department of Insurance. Okay, so you got a lot of things that are already happening here. Within a certain amount of days, I'm going to always put that amount of days to be at least the first portion of my option period. So maybe if I've got a 7-day option period, I might put a deadline of 3 days in there. And I'll typically ask for the survey right up front in my pre-offer phone call that I make to the listing agent. So a lot of times I'll just have that in my possession already. But there you go. So the seller shall furnish it to the buyer and the title company. So if the seller doesn't furnish it to the buyer and the title company, they haven't completed their obligation here, and they've got to submit the survey and the T47 affidavit, and it's a specific T47 affidavit. I think if you Google T47 affidavit, you're probably going to be okay. You're probably going to find the one from the Texas Department of Insurance, but just to make sure, go ahead and just Google Texas Department of Insurance T47 affidavit. All right, so you got to deliver both those instruments to both those people. If the seller fails to furnish the existing survey or affidavit within time prescribed, buyer shall obtain a new survey at the seller's expense, no later than 3 days prior to closing. So if they don't do it, then the seller's paying for this thing. Okay? If the existing survey or affidavit is not acceptable to the title company or the lender, then the buyer shall obtain a new survey. Here's your option: at the seller or buyer's expense. Oftentimes, I see buyers selecting that the buyer would pay for it if it's not acceptable. And I think that's kind of a mistake, because on that T47 form, it doesn't say that there haven't been any changes made since the survey was drawn. It's just an affidavit guaranteeing or allowing the seller the ability to either say that there weren't any changes or to list whatever changes were made since the survey was drawn. So let's just say a pool was installed since the survey was drawn, okay? And the seller knows full well that a pool was drawn and that survey is probably not any good. Now, morals aside, that's a totally different issue that we probably should discuss if we're involved in the transaction. But morals aside, let's say that seller says, all right, the buyer is asking for my existing survey, and they're saying that the buyer is going to pay for it if it's not acceptable. So the seller might take that T47 form and write in that no changes have been made to the property except the swimming pool is put in. Well, if the seller delivers that survey in the T47 to the buyer and the title company within the time prescribed, they've upheld their obligation. Well, there's a good chance that in that scenario, the lender's going to require a new survey to be drawn. And if that happens, then all of a sudden the buyer's going to be the one having to cough up the money for that survey. So it's just kind of sticky. There's a lot of moving parts there. I just wanted to kind of go into detail about it and explain the risks. If I'm ever a buyer making an offer, if I'm selecting option 1, first of all, I'm gonna get the extra coverage that reads shortages in area, and then I'm gonna say if it's not acceptable, the seller's paying for it, and that's probably the way I'm gonna style my offer if my client is just open to whatever. So there you go. Moving on. Section D, objections. All right, if the title commitment reveals that there's a problem with the title, some kind of defect or encumbrance to the title, then you can object to it here. You can also object to certain activities that you find out are prohibited. Or let's say you just want to ensure that a certain activity is allowed at the property, then you would put that activity here so that if it is disallowed or not allowed, then you have a way to, you're voicing your objection to that. So some examples here. Well, let me tell you what an example is not. An example is not single-family residential or SFR. That's not what should be put in this blank. If you cannot live in the house, if the house is not It just doesn't make any sense. It's a single family residential real estate contract. There's a house there. Obviously, the real estate is allowed, and you don't have to put that the home has to be allowed there. It just doesn't make sense. That's not the intention of this paragraph. The intention here is if you wanted to have like an exotic pet, for instance, like a pet pig inside the city limits. I know there was a instance of that in Keller at some point. There was so a lady wanted to have a pig as a pet pig. She just moved to town, and Keller had a ordinance at the time, probably still do, where they don't allow swine in city limits. So that would be something that you would put there. If the buyers wanted to install a swimming pool at some point, they might want to put that a swimming pool would be allowed to be installed on the property, so that if they find out later that it is not allowed, then they can object to that. If they want to install a carport or any kind of buildings, or if they wanted to have some kind of business use in the house, like for instance an in-home daycare, then those are things that you would put in this blank. Way to find out what your client is planning to do to the property, if there's something you should be putting in this blank, is you just simply ask them, hey, what are your plans to do with the property? What are your plans here? And just they'll tell you. So that's it. All right, moving on. This is one area where I strategically leave a blank empty, and it's for this little timeline here. It says that the buyer must object the earlier of the closing date or blank days after the buyer receives the commitment. So and then it says the earlier of the closing date or blank days after the buyer receives the commitment. Well, if I'm representing the buyer, I don't want to put any additional constraints on my client, just acting on their best interest. I want to give them as much time as possible. So I feel like it's to my client's advantage to not put anything in the blank that might shorten that timeline. If I'm the seller, then I'd probably want a certain number of days in there, but I've just never seen this be a big issue. If there was an activity that was mentioned, then it might become more of an issue. But so I would strategically leave that blank and move on. Section E, title notices. This is the last section inside paragraph 6, and there are 9 subsections inside this section. All right. I wonder if I could say section again. All right, so we've got section E is title notices. The word notices is a very specific word, and it carries a unique meaning in the confines of this contract. And it relates to paragraph 21. Paragraph 21 is the designated location that all the notices are supposed to be delivered to. And the notices carry certain meaning. I don't want to get into trying to define what constitutes a notice, but in the contract, if it says a notice, just realize that is a specific thing that must be delivered to that whatever location it mentions in paragraph 21. All right, so let's go. Number 1, abstract or title policy. This is something I learned about in real estate school. As a licensee, I'm supposed to recommend to every client that they get a abstract or a title search or a title policy. And if I don't, then I get in big trouble. Well, thank goodness TREC just made it as standard print in their contract here. If you're not using a TREC contract, though, you need to make sure that you're recommending that your client get a title policy. Okay. Section 2, membership in a homeowners association. It either is or is not subject to mandatory membership in a homeowners association, HOA. If it is, you need to include the homeowners association addendum to accompany this contract. One thing that it mentions in here is that if the house is in an HOA and you don't pay your dues, then the homeowners association could put a lien on the property. And next is statutory tax districts. Now, I'm not going to pretend like I'm an expert on what this means, but I know enough to know that this is kind of crazy. So let me just do what I can to explain. I'll get into detail, and then I will give you enough information so that you can go do a little bit more homework and make sure that all your I's are dotted and T's are crossed. But first, let's just read this little paragraph here. It says, if the property is situated in a utility or other statutorily created district providing water, sewer, drainage, flood control facilities and services, Chapter 49 of the Texas Water Code requires the seller to deliver and buyer to
sign a statutory notice relating to the tax rate, bondedness, indebtedness, standby fee of the district prior to the final execution of the contract. So here's the thing that I think that a lot of people miss. This has to be done prior to the contract getting executed. What that means is the title company is not going to help with this. This is before you have a valid executed contract. The seller has to provide this information. So let's talk about for just a second what a statutory tax district is. Now, it kind of gives you a hint here right in the beginning. It says, if the property is situated in a utility or other statutorily created district, providing these other services, water, sewer, drainage. So a lot of times these will be called MUDs, and that stands for Municipal Utility District, or it can just be called a water district. And I'm sure that there are other types of districts, but those are the two main types of districts that I've seen that are covered by this. Now, what is a MUD or what is a water district? Now, I'll give you a couple instances that I know of, but I am pretty positive that this includes a lot of circumstances and situations that I'm just never been exposed to. So I have seen a community that is a MUD, and what they're doing is they're borrowing the services of other nearby cities to facilitate maybe water delivery. Maybe it's like firefighter, EMS, police services. I'm not really sure. I don't know if that's really covered under this, but I think it is. And so they're paying the people that own property in that community are paying a fee that's over and above what they would normally pay, so that that area can borrow the services from other cities. Now, I'm not sure if that really hits the nail on the head, but I will say this: there is a utility district. So what a utility district is where an area needs to create basically a private district that's facilitating their own manufacturing or production of water and utilities. And so they may not always have enough money to actually fund that operation. And so what they do is they issue bonds to the residents there by basically borrowing money, and with the theory that after this community is developed, that there's going to be more than enough money to pay for all these services. But in the beginning, they've got to go into debt in order to do this. And so they basically borrow money through bonds, which is just, getting the residents to pay money. And then they'll have to figure out how to make it all work. I don't understand. It's a little over my head. But I know this: if something happens and the development of that community it doesn't go as planned, then you can have a little bit of an issue where the people in that area have to pay a lot more money than what they might have expected to pay, or maybe some undeveloped lots have to pay more money than what they would have been expected to pay. All right, so that's the extent of what I know about this, and it's just it's crazy. Now, the craziest thing is that we're expecting sellers to be able to offer this information up, and I'm just hoping that a seller in this area will know if they're in one of these districts. But then it's going to probably be on the real estate agent to help guide them through what kind of notices to get. Now, I found this notice through the Texas Real Estate Commission, and this is not really what I think. This isn't what I think that really intends, but this may work. This is a notice to the prospective buyer that the real estate agent is advising the property owner to get an abstract, which is basically like a title policy, and then right here, it's saying that if the property is situated in a utility district, then they acknowledge that we're supposed to be, it's okay. It's saying that I, as the real estate agent, am making the buyer aware that they're supposed to sign and acknowledge a notice that they're getting from the seller. So that might cover the real estate agent's butt, but it doesn't really cover the terms of the contract as far as I can tell. But I think that this is probably created just because TREC realizes that the law and what it requires is kind of crazy. And this is the best article that I've found regarding the subject, but it really stops short of being able to deliver on what needs to happen here. And I'll give you my best take, and then I'm probably going to wrap this up. So it says you need to choose from these 3 notices when selling a home in a municipal utility district. And then it goes down here and it explains that there are 3 different situations. Here's one situation if it's within the city limits. Here's another situation if it's not in the city limits, but it's within the ETJ area, which is just an area outside the city limits that is kind of like, just on the outskirts of the city limits. There are usually maps that actually lay out the boundary lines for us. Then you've got this one where if it's not in the city limits and it's not in the ETJ area, then here's another one. Now, here's the punchline is you go here and you find the water district by looking it up here. And then after you do that, then you're supposed to be able to contact somebody at the water district. There's going to be some contact information that you can find if you just dig far enough, but you can see this list. It's got all these people here, or all these water districts. Some of them are active, some of them are not. And I'm just going to click on one of them and see. Here's Alliance Regional Water Authority. Who knows? So this, all of these entities are supposed to file this paperwork with the county. So you're supposed to be able to go to the county and get one of these documents. And the county's supposed to have a copy of the notice, but I don't know. Maybe the county clerk. I'm not sure where you would go. So the seller's supposed to do this. It's just absurd. And they're supposed to do this before you execute a contract. I mean, if you're in a municipal utility district, it's probably worth it to just go through these hoops and try and figure out what in the world to do. But you should just pause the video. You can read over this. I'll provide a link down below, but I have a feeling this link may be expired by the time you see the video. And that's the extent of what I know on these municipal utility districts. It's a little bit nuts. 2 more quick little tidbits on this. I just wanted to mention that the way the law is written is to protect real estate agents and really to protect sellers, because if the buyer buys the property, then there probably will be a notice provided by the title company at closing or slightly before closing. And the law is written, to the best of my understanding, and obviously this isn't any quality legal advice by any means, but if the buyer buys the house, then the law looks at it like they are waiving their rights to have any recourse because of this disclosure issue. And so there's everybody's off the hook. As long as we get to closing, then we're all good, and the buyer's stuck with the bill. So that's comforting.
Number 4, tidewaters. This really just has to do with coastal properties, oceanfront properties. Number 5, annexation. This is if the property is in the ETJ or the extraterritorial jurisdiction area outside of the city limits of a town, and it's likely to be swallowed up by the town. This is just serving notice that area could be annexed at some point. Maybe you'd have certain taxes that would be due if it is annexed. And so just kind of be aware if you're in one of those areas in the urban sprawl situation, then you could get some extra taxes at some point if you're swallowed up. All right.
Okay, this next one is another one that I don't have much experience with, but I'm going to go ahead and dive in and give you as much information as I know, because it's unlikely that you'll find information anywhere else. So I'm the guy that's filling the gap. Here we go. Property located in a certificated service area of a utility service provider. Now, what this is saying is that there are certain properties located in a certificated area, and there may be costs or charges, or the utility company may have to tear up your property, or there are certain issues that could come with this that you really need to be aware of. And so this paragraph itself is the notice, as well as I can tell here. It's saying at the very bottom here, it says, the undersigned buyer hereby acknowledges receipt of the foregoing notice at or before the execution of the binding contract. So to me, that sounds like the notice is being given in this paragraph. Section 7 is about public improvement districts. If the property is located in a public improvement district, otherwise known as a PID, the seller must give the buyer written notice as required by his property code. And I think it's got to be done before you execute the contract. Now, the good news is the PIDs are a little easier to identify because the taxes that are collected for the PIDs, and it's not really a tax, but it is a tax, but it's the money that's collected for those is paid through the property tax bill in most cases. And so you'll have an extra tax collected. And what this is for any city services or any improvements that are made in an area where the city has to maintain them or the city paid to construct them. And so the residents in the area that utilize these get to pay for those services. And so they just collect a little extra tax for those. Just like many of these notice issues, I think the reason this became part of the contract is because there was some kind of unfortunate circumstance where somebody didn't know that they're buying a property in a PID and it cost a lot more money than they were anticipating, and they may have had some trouble paying the bills. They may have gotten into foreclosure or just had a bad situation where they were not able to afford what they needed to pay. And so the Texas Real Estate Commission actually created an addendum for this specific notice. And I don't think that this is the only notice that you could use, but there may be a PID notice from the PID. But if the PID doesn't have one, then I think your real estate agent is certainly safe just using the TREC promulgated notice and fill that sucker out as well as you can. And you want to get this in the hands of the buyer before you execute the contract, if at all possible.
All right, number 8, transfer fees. This is something that developers were doing, and it was all the rage a while back, and I think some laws were passed, and this has kind of calmed down some, but maybe there are some areas that still have private transfer fees. But it was stuff that was a fee that was imposed by the developer. It said if you sell your property, then you've got to pay the developer a fee every time it sells, no matter what. And so if you're in one of those areas, you're going to get a notice. It's kind of a sketchy deal, but maybe they've kind of found a place. Who knows? All right, propane gas system service area. There's actually a TREC promulgated addendum for this. If you're in an area that is serviced by one singular propane gas company, then there's an addendum you need to fill out. It's going to just be for a rural type situation. If you're in that area, you're going to get a notice, and it's just not going to apply to many folks, so I'm going to move on. The notice of water level fluctuations. This is a brand new section inside this paragraph. This is one of the paragraphs that were added whenever TREC revised the contracts. And so here's the reason why they added this. Texas passed a law that says that sellers must notify buyers if the buyer is buying a piece of property that has water, a body of water on it, whose water level fluctuates for various reasons. Maybe it's due to drought. Maybe it's because somebody's using a massive amount of the water. But for whatever reason, if the water level fluctuates, then the seller must notify the buyer. That's what the law says. So TREC is smart. They went ahead and just amended the contract to disclose this notice, to give notice to every single buyer buying every single piece of property, whether it has water or not, that if they are buying a property that has water, a body of water on it, and that body of water happens to fluctuate, now you've been given notice that that's a potential risk here. And so now the law that was passed is being adhered to. The seller is hereby giving notice to the buyer because it's going to be in every single real estate contract. And so now that law is completely pointless again. Thank you, government. Thank you, laws. Thank you, TREC. And I don't know. It's kind of funny, but that's what that paragraph's all about. Paragraph 7, property condition. This paragraph is broken down into 7 different parts, and they are A, access, inspections, and utilities; B, seller's disclosure notice; C, seller's disclosure of lead-based paint; D, the acceptance of property condition; E, lender required repairs and treatments; F, completion of repairs and treatments; G, environmental matters; H, residential service contract. So let's start off with A, access, inspections, and utilities. The seller must let the buyer in the door at reasonable times. The buyer may have the property inspected. The seller must immediately turn on the utilities, and the utilities must remain on until the deal's closed. TREC amended paragraph 7A to say this: any hydrostatic testing must be separately authorized by the seller in writing. So everything else in this paragraph stays exactly the same. They just added this one thing here because what a hydrostatic testing is that's testing that's done to see if there's going to be a water leak in the plumbing system of the property. And that kind of inspection, that kind of test, I assume is a little bit more invasive than just a traditional inspection. And so it has to be authorized by the seller prior to getting that. Actually, it doesn't say prior, but it has to be authorized by the seller separately in writing in order to approve that kind of testing. Side note, if the utilities are not activated during the option period and the buyer wants to extend the option period, even though the seller might be in default here, it would still be a good idea for the buyer to pay an additional option fee if they're going to extend the option period, so that, to make sure that that option period is valid. So kind of crazy. There you go. Section B, the seller's disclosure notice. We've got 3 different options here. Option 1 is that the buyer has received the notice. I'm going to skip to number 3. Number 3 is that the seller is not required to furnish the notice. And it's because of the type of seller that it might be. There are a few types that aren't required. For instance, builders are not required to give a seller's disclosure notice. A lender is not required to give a seller's disclosure if they just foreclosed on a property. If it's an estate selling a property, they're not required to give a seller's disclosure notice. I believe there's a couple other folks that aren't required. But for number 2, this is for folks where the seller did not provide the seller's disclosure notice before the contract was executed. Then they're going to allot a certain number of days that the seller has to deliver that to the buyer. It's a good idea for the buyer to fill out this and say maybe 3 days or so. But for the seller, it's a very bad idea to let number 2 here come into effect because of the second sentence here. This is crazy. Okay, third sentence actually. If the seller delivers the notice, the buyer may terminate this contract for any reason within 7 days after the buyer receives the notice or prior to closing, whichever occurs, and the earnest money will be refunded to the buyer. That's nuts. That's almost like a second option period. So let's just say that the option period is 5 days, and let's say that the deadline to get this notice delivered from seller to buyer is on day 3. So then let's say on day 3 they deliver it. Then 7 days from that point, the buyer could back out for any reason, it says. So that could be on day, let's see, 7 plus, day, depends on how you count it, day 9 or day 10. This buyer could back out for any reason. That's kind of spooky to me. So if you're a seller, you want to make sure to cough that notice up right up front. The best thing to do if the seller's complicit on this is to get the seller's disclosure notice, the survey, and the T47 form, and just upload them to the MLS and have them as the supplemental documents. And that way, most people will get those on their own. Most agents will, but even if they don't get it on their own, if they call you and ask for it, then you can at least just say, hey, yeah, I uploaded those. They're in the supplemental section in the MLS. Go ahead and just grab it yourself. And please do me a favor and check box number 1 here on the seller's disclosure notice area. Okay, next is the seller's disclosure of lead-based paint and lead-based paint hazards. If the house is built before 1978, in most circumstances, you're going to have to disclose this and provide the disclosure, to provide the pamphlet. There are circumstances where you don't have to provide this notice, but exceptions where you don't have to deliver the lead-based paint notice are, of course, properties that are built after 1978, properties that are sold at foreclosure, properties where the living area is not separated from the sleeping area, such as like efficiency apartments, dormitory housing, or individual rooms that you're, I guess, renting out. And then the fourth exception is kind of shocking. It's housing for elderly or disabled residents where no child under the age of 6 is expected to reside. In those circumstances, you do not have to provide the lead-based paint disclosure. If you're with my company, we're probably going to try and provide that lead-based paint disclosure regardless of the circumstances, if at all possible. Section D, acceptance of property condition. Easiest way to read this is to skip down here to your two choices and start by reading those. So first it says that the buyer either accepts the property as is, or the buyer accepts the property as is, provide the seller at the seller's expense complete the following repairs. And you're not supposed to insert general phrases such as subject to inspections and that sort of thing. It's supposed to be specific repairs. The types of repairs that you would list here are not repairs that you would find out about in a home inspection. These would be things that you can naturally observe by walking through the house, like torn up carpet, a broken window, who knows, things like that. But people sometimes get a little nervous about checking the as-is box because they think that it might prevent them from being able to do an inspection. Well, that's where you jump right back up here towards the top. It says, as is means the present condition of the property with any and all defects and without warranty, except for the warranties, blah, 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 blah. It does not preclude the buyer from inspecting the property under paragraph 7A, from negotiating repairs or treatments in a subsequent amendment or form terminating this contract during the option period. So go ahead and check box 1 if there's nothing you know that you want to negotiate up front. Do your inspection. Then if you've got some other items you want to negotiate, go for it. But that's how you attack that. Section E is lender required repairs and treatments. The interesting thing is that if the lender requires some repairs to be made, neither party is obligated to pay for those lender required repairs. And if neither party pays for the repairs, then the contract will terminate, the earnest money will be refunded to the buyer, and that's it. And then it gives a second scenario here that just it seems like it's contradictory or redundant, but it's really not. It says if the repairs, the cost of repairs exceeds 5% of the sales price, the buyer can terminate the contract and the earnest money can be refunded to the buyer. At first glance, it's like, why would they put that second sentence in there? It seems like the first one pretty much covered it. Well, it doesn't really. What if the cost of repairs is, say, 10% of the purchase price? And the seller is willing to complete the repairs, then it seems like, okay, well, then we don't have a problem here. Then we're going to proceed with the sale. But I can tell you, having represented buyers before in a situation like this, sometimes when the cost of repairs exceeds a certain amount, it really can freak out that buyer, and the buyer just say, no, there are too many repairs that need to be made here, and I'm not interested in pursuing a house that has had that many repairs that needed to be done. It makes me think there could be something else. So what that's saying is, even if the seller's willing to repair it, if the cost of those repairs exceeds 5%, the buyer can still back out and receive the earnest money. Section E, the completion of repairs and treatments. First of all the repairs must be made before the closing date. Secondly, if the repair involves something where a permit should be pulled, then the permit must be pulled, and licensed professionals must complete all the work. If, for instance, there is not a license governing the kind of work that is agreed upon to be done, then the professional for that industry must be the person that goes out and does the repair work. So somebody that's commercially involved in actually that industry. So let's say like a roofer. I don't know of a roofing license, but if you are getting roof work done, then it's got to be a actual roofer that's doing the repair. Let's see here. If there are warranties involved with the work that need to be transferred, then the buyer can transfer those warranties from the seller to the buyer at the buyer's expense. And let's just say if the repairs aren't done, then the seller's going to be in default of the contract. They're breaking their agreement. The buyer can either exercise their remedies that in paragraph 15, which is the default paragraph, we'll get to that here in a second, or they can extend the contract 5 days and allow a little extra time to complete the repairs. Section G, environmental matters. If there's something going on with the property or the land that's environmentally hazardous, then that could affect the buyer's ability to enjoy the property. The government could come in and wreak some havoc because you're about to get cancer or something. And so just be aware of that. If that's a concern, then there's a TREC promulgated addendum that concerns this area that you probably ought to use. And the final section, Section H, the residential service contract, otherwise known as the home warranty. It's not really a warranty. It's more like extra insurance for different components and systems inside the house. And the reason it's more like insurance is because there's a premium up front, which is going to be the amount in this blank, which the seller is going to pay for, if the amount is in that blank. And it's usually about a $400 minimum if you get the base package and the house isn't too big. There's things like square footage will increase the cost of that. You can always buy additional coverage if the home has a sprinkler system, a swimming pool, or anything else that you want them to check, maybe a septic tank. Then the cost of that home warranty is going to go up significantly. We're always going to recommend that you get a home warranty, and the reason why is because it helps prevent lawsuits. It helps everybody stay just a little bit happier. If there's something wrong with the property that you find out about after closing, then typically it's better to call somebody before you call an attorney. And so if you can call a home warranty company to hopefully fix the actual problem rather than call an attorney, that's a good thing. So we typically try and negotiate that into the contract as long as the buyer and seller are agreeable, which in most cases they are. Let's see. Sometimes you'll find that the brokers are in cahoots with these companies. Now, I can't personally recommend any company unequivocally because none of these companies have a spotless record. I mean, it's just like an insurance company. There's exceptions to the coverage, and when that happens, when that exists, people are going to get pissed if their stuff isn't covered. And the companies, they don't make money by paying out claims. They make money by not paying out claims. Now, companies also understand they have reputations to uphold, but that's just all to say that there's not one company that just completely stands out among the rest. They're kind of streaky. But there are some brokers that I guess that they earn money from these companies by recommending them because TREC has an addendum for that. And if the broker's got some kind of tight relationship with the company and maybe they're earning some money from it, then that's going to be disclosed right up front and everybody's going to sign an agreement for it. And so if you see that, that's what it is.
Paragraph 8 pertains to brokers and sales agents. There are two sections to this. The first one has to do with a disclosure issue, and the second is pertaining to brokers' fees. So, Section 8A is broker or sales agent disclosure. This is the area where you would disclose if you have a real estate license or you're related to somebody involved in this transaction that has a real estate license in Texas and is involved in the transaction. And so it goes on to list out a pretty lengthy list of folks that and the types of relationships that you might have in which you would be required to disclose your relationship. And I think that the reason they're doing this is because Investors particularly, but people that are really, really motivated to get a property, they will arrange all these creative scenarios to try and make the illusion that they're not related to somebody that's involved in the transaction so that they can achieve different creative outcomes. And this is just eliminating or identifying all these different relationships that are going to require disclosure if somebody involved in the transaction has a license. B for broker's fees is referring to how much money the brokers are going to get paid. And all this is saying is that this contract has nothing to do with broker's fees. The MLS will disclose what brokers are making and what they're agreeing to pay each other on in some cases. The confusion really comes into the next to last page of this contract. You'll see a section below the broker information, and that's just merely a disclosure. Here's the reason why this becomes an issue. It's because since those fees are secured using outside agreements, then the title company has a difficult time knowing how much to pay people. And so the title company relies on communicating with the brokers to get that stuff straightened out. This is just disclosing that and making sure everybody's on the same page that information is not part of this contract. And just bonus tip here, if you end up renegotiating your fees, or if your fee is something other than 3%, then you just want to make sure you go the extra mile to inform the title company of that, because sometimes they'll just out of habit just give everybody 3%, even though we all know real estate fees are not fixed. It's always negotiable, blah, 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 and no antitrust stuff going on here. But that's just something to be aware of to make sure that all the money is shuffled out correctly at closing. Paragraph 9 is talking about when the transaction will close. However, I always hear people refer to this as the closing date, and that is not accurate. This is the closing deadline, and I think that that's a small but significant distinction to make. If you act like whatever date is in this paragraph is the closing date, then inevitably everybody's going to shoot for that date, and the smallest little hiccup will cause you to go beyond that date. It's really the closing deadline, meaning that we have to get the transaction closed before that date, and it can happen on that date, it can happen before that date, but it shouldn't happen after that date. Now, there is a interesting caveat here that this paragraph is not, there's nowhere in this paragraph that it says time is of the essence. So what happens if you go past that date? Really, it kind of depends on how much everybody throws a fit about it. And then, if you have two parties that disagree and it goes to court, then I have no idea what a judge is going to say. I don't want to find out, though. You just have to know time is not of the essence. And so maybe if the buyer, has a car accident and they can't get to closing and they end up signing papers the day after, and the seller says, no, that's not acceptable, we have to go to court. Well, then a judge might say, well, that's a pretty reasonable excuse to not hit your closing deadline, so I'm going to go ahead and honor this, and the buyer can now buy that property. So in other words, the seller can't maybe just kick the buyer out if they don't like that they missed it by a day, if they have a reasonable excuse. I don't know. I don't know if that would be sufficient or not, but I wouldn't test it. Time is not of the essence. The deadline on this is usually 30 to 45 days after the execution date, because that's about how long it takes for a lender to get all their ducks in a row, for the title policy to get written, any HOA stuff to get settled out. But there is no, it can be anything. It could be just as soon as everybody's ready to close. So that's the closing deadline. Now, this is broken into two different sections. You have 9A and 9B. 9A is everything I just said. 9B is basically saying that the seller has to deliver this property free and clear. And so no taxes can be owed, any liens are going to get paid off. Something else that I find a little bit interesting is that it says that the funds that are being delivered and paid, the funds that the buyer is using to pay the seller, have to be funds that the title company or the escrow agent finds acceptable. So when we're entering into a day and age where Bitcoin is becoming more and more prevalent, something like that may not be acceptable to the escrow agent, but it might. I don't know. You just have to see if it's not acceptable, then they're not going to allow for that at closing. If it is, then you're fine. And so that is everything on paragraph 9. Paragraph 10 is all about possession. Inside this paragraph, there are two subsections, one for buyer's possession, and the second section, B, is for smart devices, that's a new addition to this version of the contract. So we're going to dive into both of these. Let's first start with buyer's possession. Now, there are two different options in here. It says that possession can occur upon closing and funding or according to a temporary residential lease. So, upon closing and funding, it's really important to realize that it says upon closing and funding. All too often, people will go to the title company, sign all the documents at closing, and think that they just bought a house, and that is not true at all. If funding does not occur, then it's not done, and they can't take possession of the house. They might have fulfilled all their obligations in the terms of the contract, but the lender still has to do certain things. The lender has to send over their money, and then the title company has to disperse the funds, and then only at that point has the terms of the contract been satisfied, and then at that point, then they can take possession of the house if that first box is checked. So that's really important to realize. I just want to mention this. There are so many different little incremental steps that have to be taken in order for funding to occur. And if something goes awry and that funding process has not been completed, then it may be that deal could fall apart if all of those terms aren't completed. And so it's not done until it's done and everybody's got their money. So that's the first point I want to get across. The second is just that even if all those steps do happen, it could be delayed. The difference between the time that closing happens and the time that possession happens could be two separate events, and there could be a good amount of time in between those two events. For instance, if we're pushing really hard to get closing done by the end of the week, and we push and finally at 4 p.m. on Friday, we get closing to happen, and everybody signs all their documents, but the lender hasn't already delivered all their funds to the title company, and then the title company hasn't given them an authorization for those funds to be released, then funding may not happen until the next business day. What if Monday's a holiday because we scheduled to close on this thing right before that big holiday weekend? Well, now you're going to be sitting there twiddling your thumbs trying to figure out how to reschedule, utility activation and the moving truck and all sorts of crazy stuff, contractors and all that. Now it's going to have to be delayed until Tuesday. So just realizing that these are two separate events and making sure that the buyer and seller recognize that way in advance, and especially if you realize that you're going to end up in a situation where you could be closing on a Friday at the end of the day, then recognizing that and what you're going to do is really important. It might be a good idea to talk about a temporary residential lease, which is what the second box is all about. So the second box, it only refers to a temporary residential lease promulgated by the Texas Real Estate Commission, but it can be some other kind of lease as long as it's required by a buyer or seller. A realtor, real estate agent cannot require a different type of document. We would have to use the promulgated one. But if we're using the promulgated contract, you need to know that that temporary residential lease that TREC created is designed to be a maximum of 90 days long. Boy, we've got a lot of things to talk about real quick. So something that people don't realize is that when you use one of those temporary leases, the buyer is now going to be the landlord and the seller is now going to be a tenant. So now you've got a typical landlord-tenant situation, and oftentimes there's been no credit check, no criminal history check, no background check of any sort, no credit check. The likelihood that there's no deposit is pretty high, and sometimes there's not even a lease payment. And so you've got these situations where there's no screening that's been done, but yet now that buyer is a legitimate landlord, just like any other landlord you've ever heard of. So realizing that before you enter into this document is very important. I don't encourage these things, but when you've got an extreme buyer's market or seller's market, then you'll see this kind of thing get negotiated in the majority of deals. I don't, like I said, I'm happy to do it as long as the buyer and seller understand the ramifications. I don't try and talk them out of it. I just make sure they understand the situation that they're getting into. Now, what happens if there is no temporary residential lease and that seller doesn't move out of the property once it's funded? Well, then we enter into the situation C, the third situation that's spoken about right here. And this is something that nobody would choose to have happen. But if the seller does not adhere to the terms of this contract and they stay in that property, then it establishes a relationship which is called tenancy at sufferance. That means that the seller now has become a tenant against everybody's will. I guess the sell. So now you've got all their stuff in the house. They might be in the house, and you got to figure out what to do. Well, they still have rights. You can't go in there and just drag them out and arrest them, or you can't just bust down the door and demand that they get out. You've got to actually go through the process of filing an eviction. Do that 3-day notice, and file the eviction, get the eviction granted, and then if they still haven't left, you have to do the writ of possession before you could ever get a police officer or constable to come to the house and kick them out of the house forcibly. So those are the different situations with that. The final part of this first section talks about insurance coverage, and I'm so glad that they're putting this in here because this is something that is easily overlooked. It's in bold print. It's very important. If the buyer is not occupying that property immediately after closing, you have to realize that they may be violating the coverage terms of their insurance. A lot of insurance requires the buyer to begin occupying that property within 60 days after closing. So if there's a temporary residential lease, now they've got a tenant, whereas they might have had a owner-occupied insurance policy. Well, what if there's a temporary residential lease? Now they're a landlord, and that's a different type of policy usually. If they need to fix up the house and there's construction that's going to happen there, well, then now you've got a completely different type of insurance policy. The best thing that you can do is be honest with your insurance agent, explain to them when you're going to gain possession of the house. If you're going to be doing a major rehab project and remodel the house, and explain all that stuff, because the last thing you want is for some kind of catastrophic loss to happen. You file the claim on your insurance, and then the insurance company come out and realize that maybe you didn't occupy the property within the right amount of time, or something happened, and now they're not going to cover this catastrophic loss issue. Section 10B has to do with smart devices, and they've put this in the possession section. However, this paragraph really ties into certain things in paragraph 4 and paragraph 2, and these are all new additions to this version of the contract. And the reason why they put these in here is because smart devices are now part of our everyday life, and it really extends into all sorts of different elements. We've got doorbells and nanny cams and all sorts of different things where you got smart TVs, garage doors, lights, alarm systems. Anything electronic that requires a username and a password may be included in this section. And so we had some issues where new buyers would buy a house and the sellers would say, hey, by the way, I love what you've done with the living room. Well, it's because they were still watching the cameras or something, or maybe the smart TV remained at the house and now the new buyers are watching the old people's, the outgoing sellers' Netflix and that sort of thing. And so they had to figure out what to do with this. And so what we've done is they created this paragraph that defines what a smart device is, and it requires them to do two different things. One is to deliver all of the items that are necessary so that the new owner can operate and access and manage all of the smart devices. So that might include giving over username and passwords, maybe a web address, maybe they would have to relinquish some kind of ownership of an app so that the new person can take control of an app if that particular app was tied into a geographical location, like security measure kind of thing. I'm not sure, but it just covers those bases. The other thing it requires is for them to terminate their access to those devices so that they can't watch the new owners in there partying it up in the new house. So oddly enough, part of your real estate contract might involve you deleting an app off of your phone in order to make sure you're not defaulting on your obligations here of this contract. It's a new world we live in. So we've got those two elements. You got to deliver information to the buyer. You have to remove your access, give the buyer access. And this is going to apply to items that are fixtures in the home, or that may be specified in a non-realty items addendums. For instance, what if you're leaving the refrigerator and it's a smart refrigerator, and then now that refrigerator is covered under this smart devices section. And I also want to remind you that the leases that are mentioned in paragraph 4 may tie into this a little bit. If there's a associated lease with one of these items, smart devices, then it's going to have some kind of tie in to that. I also want to kind of jump back into paragraph 10A and mention that when you are transferring ownership without transferring possession, the buyer's temporary or the seller's temporary residential lease says that you have to hand over keys to the new owner so that the new buyer, who's now the landlord, can access the property and conduct inspections with. In that temporary residential lease, it says that the landlord may enter the property at reasonable times to inspect the property, and the tenant shall provide landlord door keys and access codes to allow access to the property. So some of these smart devices may have access codes that would be governed by that provision in the temporary lease. If you're a real estate agent and you're trying to figure out how to guide a client through this process, what I would recommend is just put together a checklist so that you notify every single seller at a certain point in the process, maybe a week or two before closing, to change all their passwords, clear all their data, and make sure that they understand that they're leaving behind their Nest thermostat, their nanny cams, their ring devices, Netflix stuff, and clear everything off and reset passwords. And then if they have to deliver a password over to that buyer, to make sure they're not handing them a password that they use on several different devices, that it's a unique password.
Paragraph 11, special provisions. All right, this is a hot button little paragraph. If you'll notice, as the TREC contract keeps getting revised, this section keeps getting smaller and smaller, and there's a reason for that. Texas Real Estate Commission doesn't like us writing stuff in this blank because real estate agents tend to write crazy stuff in the blanks. They want us to stick to just factual statements or statements that clarify maybe terms of the contract or different details of the contract. However, principals, the buyers or sellers, can write whatever they want in these blanks. It doesn't matter. You can write something on your own behalf, but as a realtor, I don't have any authority to write stuff here. If-then statements would be practicing law without a license. For instance, if you don't respond to the contract within a certain amount of time, then the contract becomes void or whatever. You just have to be careful about that because if you're practicing law without a license, you could lose your real estate license. Also, if you want to say something here that there's already been a TREC promulgated addendum for, then that's absolutely prohibited. You cannot do that. So just a couple of bad ideas of things to write. Bad ideas would be personal property is conveying. That's not a good idea. For one reason, there is a personal property addendum. Secondly, it's not just factual statements. And so if you're using that addendum, just kind of a side note, a good idea is to take photos of the personal property that you want to convey when you're using one of those addendums. So that was a bad idea. A good idea of something to put in this blank would be if you've got a buyer whose name is super, super long, then you can just say in maybe the buyer's name blank, see paragraph 11, and then here in paragraph 11 you could write out the full buyer's name. Or if the legal description was too long, maybe it had a meets and bounds legal description, or just for whatever is too long, you could continue it here. Another acceptable section thing would be if an attorney drafts some language for you, you're more than welcome to enter it there. If you find that this little section is too small to fit everything you want, then you can always use the TREC promulgated special provisions addendum to continue all of your free writing. Paragraph 12, settlement and other expenses. This section, or this paragraph, is broken down into two main parts. You've got A, which is expenses that must be paid at or prior to closing, and then you've got B, which is a way that the contract can be terminated because of some fees. Inside A, you've got two sections. You've got one section for the seller fees, seller expenses, and then you've got another section here. Number 2 is for buyer expenses. So let's dive into section A1, which is the seller expenses that are to be paid at closing. And then that is broken up into 2 parts. So you've got 12A1A. This is actually something to pay attention to because at closing, everybody's looking at the settlement statement, and there are so many fees that are paid off of each side, and sometimes many times actually, your client will ask, why is this fee on my side of the settlement statement? Well, it's because of 12A1A. Releases of liens, including prepayment penalties, which isn't all that often, but recording fees, release of seller's loan liability, tax statements, certificates, preparation of deed, 1/2 of the escrow fee, and other expenses paid by seller under the contract are in this section. That covers a lot of stuff. That's going to clear up some mystery for you there when somebody started asking why a fee is on my side. All right, B is a pretty fun little blank here. You can do a lot with this. B is for the seller to pay for an amount not to exceed blank to be applied in the following order. I'm just going to read this because I have to. The buyer's expenses, which buyers prohibited from paying through FHA and VA, or the Texas Veteran Lands Board, or other governmental loans, and then whatever money's put in that blank, after all that's taken care of, then it's applied to buyer's expenses as allowed by lender. That's a really broad statement there on that second half. You can cover a whole lot of stuff. Anything that the lender allows, you can be covered out of this, and the lender allow more than you might imagine. So couple notes here. First of all, the numbers in this blank, they tend to be quite large, into the several $1,000 range, and so you just want to make sure that you're not going to exceed the lender's loan limitations. FHA allows for up to 6% of the purchase price to be included in this blank. So what that is 6% of the buyer's closing costs to be paid for by the seller. So you also have to realize if you're adding money to the seller's side of the settlement statement, then that's just however much money you add to the seller's side, that's that much money that seller is going to lose or not make. It's going to reduce the seller's net. So if you're a buyer, you're making an offer, putting money in this blank, you might want to consider increasing your offer amount to compensate for whatever money you're putting in that blank. If you're the seller, then you want to make sure that you flip to this page here and page 5 to make sure that you see how much money is in that blank so that you just automatically subtract that from the total purchase price, which a good realtor will do right off the bat. We're not going to be fooling anybody by putting any money in this blank. Everybody just makes their decision based on what the net of the proceeds are, but still it could be an oversight if you don't watch out. One thing that I like to do is I like to, if I can at all, and I'm representing the buyer, I like to not put any money in this blank and do my best on purchase price, because that's where a lot of negotiation is going to come from. And then that way, if I am using some financing that allows for seller paid closing costs, then I'll go ahead and proceed into the deal, get into the option period, do my inspection, find out what repairs need to be negotiated. Then if I've got some repairs that I get the seller to agree to pay for, then I may, instead of actually getting money for those repairs, or maybe it's just some upgrades that I want done to the house, all I really need is the money so that I can do those myself. So what I would do is, if I was the buyer, what I would do is I would ask the seller to give me X amount of dollars, providing it fits within my lender's loan parameters, and ask for it in this blank. And so by not putting anything in this blank ahead of time, it gives you that room to add the money later on, amend the contract, and either negotiate repairs or upgrades and include it in this blank. Because if you start trying to negotiate repairs, like specific itemized repairs, then it could cause questions, and the lender might take something that's a really pretty harmless repair item and cause want to investigate it further and get additional inspections and cause the contract to kind of wobble a little bit and fall into jeopardy of falling apart, whatever. Okay. I know it says it right here, but I just have to repeat if your buyer is using FHA or VA, count on something being in that blank because they're expenses that they're going to have that they just can't pay. So don't look at it as all that bad. It's just a fact of life if they're using that kind of financing. All right, now let's go on down to 2. It says buyer's expenses. Again, I'm not going to read through this whole thing, but it just goes through a lot of really helpful things to know when your buyer is sitting there looking at the settlement statement and they see that itemized list of charges, and they're going to ask, why is there a final compliance inspection fee on my side, or why is there a wire transfer fee on my side? Why isn't the seller paying for that? Well, it's because it lists it right here in this section. All right, moving down to B, this is kind of interesting. If there's an expense that has been agreed upon in the terms of this contract and the expense ends up being much greater than what what everybody thought it was going to be, then this is saying that the party can get out of the contract. The contract can be terminated if expenses end up being more than what they expected. Chapter 13, prorations. This is just the only fair way to do it. This is saying that whatever expenses there are, they're just going to be paid by the party that incurred the expenses. So property taxes is the biggest sticking point here. There's only going to be one property tax bill sent per year, and it's sent at the end of the year. So the new owner is going to get stuck with the entire property tax bill for the entire year. However, the new owner will have only lived there for a portion of the year. So the way that the title company makes sure that the new owner isn't having to foot the entire bill is for the entire year is by collecting an estimated amount of what they think the property taxes are going to be at the end of the year. They collect that prorated amount, estimated prorated amount from January 1st through the day of closing, and they get that amount from the seller, and the seller pays that to the buyer. That way at the end of the year, the buyer's got that money in their possession, then they go ahead and just pay the entire tax bill. There's something here that I haven't ever personally encountered, but that is this proration amount is based off of an estimation of what they think the taxes are going to be. Well, if the taxes change drastically, then that might mean that the amount that they collected from the seller up front was either drastically higher or drastically reduced from what it should have been. And so this paragraph says that they'll actually, I guess, come back together and adjust whatever amount it should have been and either collect money or give money to the appropriate party well after closing. That's what I interpret this to be. It's kind of freaky. Chapter 14. If the property is burned down or damaged by flood or something, then they can either terminate the contract, or buyer could extend the time to allow the seller to fix up the house, or the buyer could accept the property in its as-is condition and accept remedies some other way. Finally, paragraph 15, the default paragraph. This is the paragraph that you need to become familiar with, because if anybody is not upholding their obligations and agreements in this contract, then they're going to be in default of the contract, and this is where you're going to come to read what kind of remedies are available for the defaulted situation. So let's say if the buyer fails to comply with the contract, the buyer will be in default, and the seller can enforce specific performance and seek such other relief as may be provided by law, or both. Or they could terminate this contract to receive earnest money as liquidated damages, thereby releasing both parties from the contract. If the seller fails to comply with this contract, the seller will be in default, and the buyer may either enforce specific performance, seek other such relief provided by law, or both, or terminate this contract and receive the earnest money, thereby releasing both parties from the contract. So you see, each party has the same exact options on how to remedy if the other one defaults, but it's really not very equal, because the specific performance thing I think would be a little harder to enforce on a buyer. I've seen a bunch of attorneys recommend that the seller always scratch out the specific performance clause here, and leaving only, I guess, other relief provided by law and possibly the termination option here to get the earnest money back. But the interesting thing to me is if the contract is terminated and somebody gets a hold of that earnest money, then that ends it, according to this. That says that releases everybody and the deal is done. So, paragraph 16, mediation. I love this little paragraph, even though I think it's kind of silly. It's just saying that if there's some kind of conflict that arises as a result of this contract, then everybody's agreeing to go to mediation. However, it also says down here that this paragraph does not preclude a party from seeking equitable relief from a court of competent jurisdiction. So basically, it's just hopefully setting the expectation in everybody's mind that we're going to go to mediation and not go to court and try and obliterate each other. We'll try and actually solve the problem instead of just fighting all that much. But if we really just wanted to fight, then we could ignore that paragraph altogether and just go fight and go to court. So there you go. And if we do go to court, let's talk about paragraph 17. You got attorney's fees. Basically, it's just saying whoever wins is entitled to recover reasonable attorney fees.
Paragraph 18 is titled escrow, and it has 5 different sections. It's A is escrow, B is expenses, C is demand, D is damages, and E is notices. One thing I want to mention that may be obvious for some people, but not so obvious for others. I know when I started out, the word escrow caused great confusion for me because I knew that every house with a mortgage usually had an escrow account where the lender would hold taxes and insurance. Well, this is not that type of escrow account. This is an escrow account at a title company, and it's where they hold the earnest money in escrow or hold funds in escrow prior to closing. And so the term escrow is more of a universal term. It's just that we normally only hear about it in the context of an escrow account with the mortgage, or in this case, escrow in terms of a real estate contract. And so that's the purpose for escrow here. Let's dive into it one section at a time. The first section, A, escrow, says that the escrow agent is not responsible for a whole lot. It's basically just a liability waiver saying that they're not a party to the contract. They're not in charge of the performance of the buyer or the seller. They're not going to be held liable for a bunch of stuff. And if they can blame any earnest money loss on a bank, then they're going to try and do that and maintain zero liability in the situation. Now, there is one sentence that is new to this paragraph. It says that the escrow agent may require any disbursements made in connection with this contract to be conditioned on the escrow agent's collection of good funds acceptable to the escrow agent. This is a very common sense thing. It's basically just says that if somebody wants money that has been paid to them, paid to the title company, that the title company now gets to wait until that money has cleared the bank before they release that money. And I think that the reason why that sentence was added is just because now the title company or the escrow agent is now in charge of collecting money for the option fee. And the seller is now entitled to receive that money anytime they want it, but with this caveat that the money's got to clear the bank first. So you just have to be aware that if the title company wants to wait 15 days or so to make sure that money's cleared the bank, that they can do that before they release any funds. Paragraph 18B is about expenses having to do with escrow. And the first section says, at closing, the earnest money is going to be applied first to the cash down payment and then to the buyer's expenses, and then the excess funds returned to the buyer. Now, it's important to note that this is at closing. If no closing occurs, then the escrow agent has a few different options. So basically what they're going to do is they're going to take care of any kind of expenses that have been incurred throughout the transaction. The most common expense in this situation would be if somebody ordered a survey. Oftentimes surveys are paid out of closing proceeds, and if that closing never happens, then the surveyor now is going to be authorized to pay for that survey. One other thing that I want to mention is that most people think that if two people disagree on things, and one person bails out of this contract and they default on the contract and they don't uphold the terms of the agreement, that the other side can get the earnest money. And it's just not that easy. This paragraph is the paragraph that makes it not that easy. It says that the title company or the escrow agent now says that they can require the parties to sign a written release of liability before they release any of that money. And so what ends up happening in practice, and I've been involved in this a number of times, is that the title company will send out a note or say, hey, yes, I understand you want the earnest money. I need you to sign this sheet of paper, and everybody in the transaction needs to sign this sheet of paper, basically stating that everybody agrees that this one person should get that money. And if somebody doesn't agree with that, then we go through this process that's outlined in the next few bullet points. Paragraph 18C is the demand paragraph. This is a very important paragraph, and if you do enough transactions, you will inevitably have to use this paragraph. So it's worth it to read every single line of it, especially if you're in a situation where somebody's trying to exercise demand to get the earnest money. And so it just is relating to a situation or pertaining to a situation where somebody wants to back out of the contract and they're making a demand on the earnest money. Well, the title company or escrow agent, they are not a judge, and so it's not up to them to decide who should receive that earnest money or not, and they want to do everything they can to not get sued, so they want to try and remain blameless and faultless in this and just as unbiased as possible. So they just say, hey, look, if you can get everybody in the transaction to sign a sheet of paper saying who the money should go to, then great. We'll go ahead and release the money to that person. If not, if you can't get everybody to do that, then if you feel like you're entitled to that money, then you should send a demand letter, and the title company will acknowledge that demand letter, and then they'll let the other party know that there's been a demand on the money. And then if the other party doesn't respond to that demand letter by giving another demand, then what'll happen is they'll wait 15 days and then they'll disperse that money. And this paragraph here says that if the title company goes through that process and they receive the demand letter, release the earnest money, as long as it's been done in accordance with this, then we will hold them legally not liable. And of course, if there's any money that's owed in the transaction, it's going to be taken out of that earnest money before the money's released. And paragraph 18D says that if you are notified that there's a demand made on the earnest money, a release has been sent out, and you don't respond to that and sign it within 7 days, and then you find out that you're actually liable for, you should have signed that release, then what'll happen is you're going to be responsible to the other party for damages, earnest money, attorney's fees, and all costs of the suit. It's big trouble. It used to say triple times the damages, and then that got amended, and now it says this. But one way or the other, it doesn't matter. This is serious. You don't want to hold up a transaction or hold up someone else's money. You don't want to delay too long. You've got 7 days right here, and if you're in this situation, you need to stop, turn off the recording, and read every single word of this, and probably get some legal advice. Paragraph 18E is just about the notices. It's saying that the escrow agent gets to deliver those notices to the contact information provided in paragraph 21. So it is just even more importance that you make sure there's some kind of contact information in paragraph 21 so that they can enforce this nasty little paragraph here to make sure that all the money is divvied up and handed out in accordance with the contract, so that hopefully we don't have a mediation situation, which is what I think it would go to if you didn't gain agreement after the title company went through this whole process.
Paragraph 19, representations. This is just saying that if the seller represents the property or something being a certain way, that even after closing, they can be held liable for whatever they said. Those representations survive past closing. And then also says that the seller may continue to show the property and receive and negotiate backup offers. So if your buyer's under contract and they just see people coming in and out all day long, that's perfectly well within the seller's right to keep showing that property. Paragraph 20, federal tax requirements. If the seller is a foreign person, then the title company may withhold some proceeds from the sale to make sure that all the taxes that need to be paid are going to get paid. Paragraph 21. We've heard so much about you. Here we are. All right, notices. All notices from one party to another must be in writing and are effective when mailed to, hand-delivered, or transmitted by a facsimile or electronic transmission to these following locations. If it's blank, then let's get that sucker filled out, whatever it takes. Let's get it filled out. If it's blank and I'm not able to get the other party to do it, I'm probably just going to fill in the other party's information as best I can. If they don't agree to it, then they need to put a line through it and change it. But I'm going to want to make sure some kind of contact information is in those blanks. And it's not a good idea to just put the agent's information in the blank, especially if you're that agent. The reason why is because if you go on vacation or something, and even long after the deal's over, there are a couple notices in here that still may be delivered, depending on a circumstance or two that could happen. But anyway, if your contact information is the only information in there, then it's going to cause some kind of delay between the time you get it and the time you relay it to that client. And that delay could cause a problem that you probably don't want to and shouldn't be held responsible for. So always put the client's information in there. Perfectly acceptable to say, copy me, copy the agent on this correspondence here. Just a few more mentions here. Time is of the essence in almost all of the TREC contracts notice provisions, and some of the notices require time-sensitive action by the party receiving the notice. For example, the seller's notice to the buyer of the acceptance of another contract under the addendum for sale of another property by the buyer remains, which is a contingency contract, requires action by the buyer. And if the notice was sent to the party's agent, then the agent would need to relay that information to his or her client. The additional step could cause a delay that might result in the client losing a time-sensitive reply option or right. And also, the word notices in this paragraph, it has a contractual meaning. Giving notice to a party can affect the party's rights and obligations in several parts of the contract, such as, say, paragraph 23, the termination option, and the third-party financing addendum. And therefore, care needs to be given and taken to provide methods of notice that don't cause needless delay. Some agents are reluctant to put the buyer's or the seller's contact information in paragraph 21 because they think that direct contact with the other party is forbidden. However, as long as you're using the contact information to provide notice to the other party, you're not really crossing a boundary of soliciting another agent's client or doing anything that's going to jeopardize the contract. Paragraph 22, agreements of parties. Some agents actually start filling out their contract by turning directly to this section first and marking off all the boxes. That way they just don't forget, and it's just kind of a reminder to help jog their memory of possibly an additional addendum that needs to be included that they weren't considering before. So that's a pretty good idea. So here you're just checking off the boxes of all the other addendums that are going to accompany this contract. If you had an addendum that wasn't listed here, such as sale of personal property or whatever, then you would check off the other box and list it in that blank. One thing that you would not put in here is the information about brokerage services form. That's not an addendum. That's just a disclosure. It's not a part of any kind of agreement. So anyway, consult an attorney before signing. The contract here reminds you that TREC prohibits real estate licensees from giving legal advice. I would take it a step further and say, just don't get any legal advice from anybody except for a licensed attorney, not just a realtor. And then it reminds you to read this contract carefully. So here's what you need to do. You need to read the entire contract so that you can get to paragraph 24 and read the sentence that tells you to read the contract carefully so that you can know to read the contract carefully. It's kind of funny. Anyway, moving on. If there is an attorney involved in the deal, you want to list the attorney's information in these blanks. I would include them on all the correspondence, carbon copy them on the emails. And then just realize that the attorney is probably going to have more authority in the transaction than a realtor would, and the attorney can do anything that a realtor would do in the contract. You want to talk to your broker about how the commissions might be split up. If the attorney wants a piece of the commissions, then they're certainly entitled to it, but there could be some extra rules or circumstances that would come into play that you want to just deal with on a case-by-case scenario. Now, one thing about the intimidation factor of an attorney, just because they're an attorney doesn't mean they're some kind of big, bad, crazy dude that has more authority than God or something. I mean, they can't do anything more than what the client could do for themselves. Really, the attorneys just has the authority to act on behalf of their client. So if the attorney's involved in the deal and they're inserting crazy clauses into the special provisions or attaching additional addendums or whatever, or telling you what to do, just kind of tap the brakes for a second and sure, give that attorney plenty of respect, but you don't have to just lay over and let the attorney rule the roost here. You've still got to look out for your client's best interests, and you got to make sure that things are heading in the right direction for the transaction. So I think it's always a good idea just to include your broker, make sure your broker knows when there's an attorney involved, because there are going to be some extra dynamics involved in the transaction that you're not going to be accustomed to dealing with, because the funny thing is that attorneys are generally not involved in the transactions under, say, the $600,000 mark or so, and it's still just not very common for attorneys to get involved in these residential real estate transactions for some reason. I'm not sure why, but anyway, there you go, moving on. Okay, let's look at the box right above the signature lines there. The one that says executed the blank day of blank, the effective date. The one that says broker, fill in the date of final acceptance. So for some reason, this box is overlooked quite a bit. People just forget and neglect to put the date in there, but that's a big mistake. Now, the contract can actually be a valid contract. If everybody signs it, then it's legit and it's done. But without the date in there, you're just setting yourself up for inevitable confusion and a possibly a conflict, because nobody's going to know what date to begin all the timelines from and what kind of counting to begin, when certain things come into effect and when certain deadlines end, and that sort of thing. So it's absolutely important to fill in the date of this contract. Now, we've got to talk about, when is a contract actually executed? It's not as simple as you would think. It's let's just run through a scenario. Let's say the buyer initials everything, signs the offer, sends it over to the seller. Seller decides they don't like it exactly the way it's written, so they strike through one or two things, initial those changes, initial every page of the contract, sign the contract. So now they send it back over to the buyer. So now the buyer's got a completely signed and initialed contract except for one change, basically. And all they've got to do is initial that one change, and then they think they have a deal, which they might, but it isn't over yet. So let's say that buyer now initials the change. Now, how's that seller supposed to know that they have a deal? The seller hasn't seen the contract. The seller doesn't know. So it's not actually a done deal until that seller finds out that the deal has been accepted. So the buyer can't really execute the contract. They should send it back over to the seller, then the seller execute the contract. Now, I'll tell you that in practice, that's just not very practical. So the way that we handle it in our office is we just want to make sure that everybody understands that the contract is final, it's all agreed upon, and it's executed. And so let's say in that situation, if I was representing the buyer's agent, I would get my client to initial that one last change. Then I would just pick up the phone and call the other agent and just say, hey, we just accepted your contract. Do you mind if I put the executed date here on the contract and then go ahead and send it over to the title company? 9 times out of 10, they're going to say yes. So that solves any kind of issue that you're going to have. If they say yes, then you're good to go. And that's how you execute a contract. Now, just below the executed box, you'll see where the buyer and seller sign. This seems pretty self-explanatory. Your client needs to sign the contract. There are going to be circumstances where this isn't quite as clear-cut. For instance, when we're going over the contracts in a contract training, everybody wants to pretend that we're all just, everybody's going to toe the line on everything that's right and wrong, and that's primary objective. But in the transaction, the objective is serving your client's best interest and reaching an agreement. So if one party or the other isn't available to sign, then sometimes the question will come about, well, who really has the authority to sign this contract? Does if you got a husband and wife and the husband can't be there, can the wife sign for the husband? I'm just not going to touch that in this contract training. This is kind of a basic contract training, but that topic needs to be addressed, and how the signature needs to appear, whether it's the same kind of signature that's on the loan documents or that's on the driver's license. And let's say if it's a power of attorney or a company, how to actually sign the contract, it may make a difference. So just realize the situation that you're in, get specific advice for your situation, and make sure that the blanks are signed, and we'll leave it at that.
Congratulations, you've made it through all of the agreements between the buyer and the seller, but we still have a few pages to go because there are some pages that do not contain any agreements of the terms between the buyer and the seller. This page is the broker information page, and this is just for informational purposes only. There are no agreements on this page. In fact, at the very top it says, print names only, do not sign. Don't sign this document. We don't want anybody confused about the fact that there's no agreements happening here. But we have all of the spaces for the fields for real estate agents and brokers and everybody to put their names down. So the top left, it says the other broker firm. This typically is going to be the firm that represents the buyer agent. They don't say buyer agent firm because you can actually be two different types of agents here. You can be the buyer only as buyer's agent or the seller as listing broker sub-agent. Now, this is something that's not used very much anymore. Now, I would imagine that at some point this is going to get taken off the contract, and we're going to get an amended form, and we won't see this much anymore. But the seller agent could have a sub-agent. And so a long time ago, where this came from is that used to there weren't buyer agents at all. There were just seller agents and then sub-agents of the seller agents. And so if there were two real estate agents involved in the transaction, they would both represent the seller on some capacity. They wouldn't represent the buyer. The buyer would always go through the transaction unrepresented unless they had an attorney or something like that. But buyer agency is a new thing. So on this document, they have other broker firm because that includes the buyer agency. So now, as we continue down the page, it says associate's name. That's going to be the name of the real estate agent, and you see their license number there. Now you have team name. Team name, this is not a legal name necessarily. It's usually an assumed name, or a DBA has been filed for that broker to operate under that team name, and it's just an organizational structure inside the brokerage company that this agent happens to be a part of. And we're just putting team name on this document because it's become so prevalent in real estate, and that it's now become part of the document because it's prevalent, and it just helps ease of use. When you see a team name used over and over again, it just helps us to know that they're all associated. I could probably explain that better, but I think you get it. All right. Moving on, associate's email address. Then you have licensed supervisor of associate. This is the same kind of thing, whereas the team name, there's no legal authority that the supervisor has. Most of the time, they've been granted an authority by the broker to do certain activities on behalf of the broker to support and supervise the real estate agents, but that still does not alleviate the broker of any responsibility. The broker is still responsible for the authorized acts of its salespeople, and you just have the supervisor down here because the common practice is that there are oftentimes a supervisor that's helping that broker out, and that's going to be the point of contact, so they just put that form on the blank. All right. So top right, you have listing broker firm. That all makes sense. Then you have team name, all the same fields. I just want to mention that the selling associate's name and all that information, usually that does have something to do with buyer agent. But in this case, it's if you have two different agents involved in the transaction, then you're going to see them listed here. On two different agents on one side of the transaction. You'll see them listed here. All right, at the bottom, we've got some language that says that this document is acknowledging that there's a fee that's been agreed upon by basically the buyer agent and the listing agent. The listing agent has agreed to pay the other broker a fee of blank. And this is not the agreement. This is just bringing whatever agreement has taken place, and now it's making it, disclosing what that agreement is on the contract. This helps title companies significantly, because without some kind of disclosure, then they have no idea what to pay the agents, because the actual agreement of what is supposed to be paid happens outside of this contract. Most of the time, that agreement is embedded inside the rules of the MLS or the rules of the Association of Realtors that says whatever fee has been advertised on the MLS is now a contracted fee between two agencies, because they're a part of this association, being the Association of Realtors, and everybody's agreed to these terms. And so now if you go show this house and this agent gets it under contract, then the listing agent has to pay the buyer agent a certain amount of money. So that's what this is here for. It's just a disclosure, and that concludes that page. We have finally made it to the receipt page of the contract. Again, this page does not contain an agreement between buyer and seller. This is for informational purposes, but it is vital information because there are so many different crucial elements of the contract that hinge on when these different components are received. And so starting at the top, you have the option fee receipt. This is a receipt, just like a receipt you get at the grocery store. This is a receipt that the title company or the escrow agent will provide when they receive the option fee. Then you can see that the next one is the earnest money receipt. Same thing. This is just them saying, I've received it. When they sign it and put the time and date in here of when they've received the earnest money, that's them acknowledging that it's been done, and this is your proof of that. Then you have the contract receipt. They will sign this saying that they received the contract at a certain date and time here. Actually, date and time isn't on that blank. It just shows the who received it at the title company. Then you have additional earnest money. We don't see that one very often, just because there most of the time there is not additional earnest money involved in the transaction. So I just want to mention that whenever I'm delivering the option money, earnest money, or contract to the title company, I'm always trying to find the most efficient way to go about serving my client's highest and best interests. And if I was to ever decide to put this contract in the mail or allow somebody else to take the contract and deliver it for me, then I have to realize that I'm personally taking a risk that external variable could cause a delay. If there's a delay in the mail system, or if I hand this document or hand the money to somebody to deliver, first of all, you might want to double check the rules based on that. But I'm always a little bit concerned about making sure it gets there in time, because if the courier or if the mail system was to experience a delay, then that does not relieve me of the responsibilities that I have to deliver this stuff in time to meet the obligations that are in the contract. So just wanted to mention that even if I have a tracking number and on, I feel a personal responsibility to make sure this gets there in time. And I'm not saying that that means you shouldn't have a courier or shouldn't use a mail service. I'm just saying that you absolutely must need to acknowledge the risks that you're taking with that. And that is it for that page. And that's it for the whole training. Just want to thank you. If you listen to this whole training, thank you so much. God bless you. This is long, but it's thorough, and it's just a very important thing to know inside and out. When you understand in detail how the contract is structured and how it's written, it gives you the parameters that you have to negotiate within, and it actually allows you the ability to exercise additional creativity and discover different options on what is allowed, because when you can be confident of what's not allowed and what parameters you have to work in, then it frees you up to do that. And by mastering this contract, you are in a much better position to be able to execute on the fiduciary duties that you have to your client. So thank you for that. If you are a buyer or seller, I would love to help. If you have questions, leave comments below. And if you're a real estate agent that needs a place where we value training and value supporting agents, and we have a tremendous amount of opportunity, and we never have enough people to take advantage of the opportunity. We have more leads than we can handle. Then please reach out. I'm more than happy to help train, and I'm excited to work with people that share the same values so that we can go out there and serve clients and make a great living doing it. And that is it. Thank you so much. Have a great day.